Hi guys! We have the YSL bond and plea day. So we're going to find out right now. What's on the screen is Judge McBurney. You can see some action in the court. This is supposed to start in like a minute. This is going to be the bond hearing for Deamonte Kendrick. Fingers crossed here for Kayla Bumpus. Probably a nerve-wracking thing, knowing that everyone's going to be watching on the internet. At 9:30, there is the plea hearing for the remaining 5 co-defendants in front of Judge Whitaker. And also at 9:30 is the final plea / status hearing for Shannon Stillwell. So we're going to get to all 3. We're going to have to juggle what we're watching when. But yeah, it's like a plea and hearing bond marathon. So
what's the word?
And I don't know how many people they're going to bring in to do bond this morning. It might be quite a few people, so it might not be Deamonte Kendrick right away, just so you guys know.
Okay, so they let the attorneys keep them. Yeah. Good. Okay. Good morning. So yes, you can let people come in and then bring up whoever's here, and we'll start with that. Good morning. Thanks for your message.
First come, first serve, it sounds like. Guys, in the chat, I'm going to be posting a link.
So we're going to start with whoever they bring up.
This is going to be the legal vices. Legal Vices passed away this weekend. A lot of you in the chat might know Legal Vices. Legal Vices is someone I've watched for hours and hours, for days and weeks at a time. Watched entire trials with Legal Vices. He wanted to get to 100K. If you guys don't know, when you get to 100K subscribers on YouTube, you get a cool placard from YouTube. So rest in peace to Legal Vices. I'm going to pin his channel. If you guys want to help get him to 100K, that would be amazing. And I know a lot of people in the chat. I see, like, Patty B. I see Brittany. Really well known. I don't know anybody that has a bad thing to say about Jeff. But if we could get him to that moment, I assume it would go to his family at this point, but just how cool would that be? And yes, Doug, this is the hearing for Yak. Yes, this is for Yak.
I don't see any prosecutor here. It's just a little tricky.
No prosecutors.
All right.
It's always crazy watching this in Florida, seeing like the jackets. There's Adam.
Where's Miss Clark?
Should be on the way.
Shout out to the Fit Lawyer ATL in the building. Good to see you.
Okay, she didn't say anything about that, that's fine.
No, he's right.
That's good.
Okay, this microphone is like making everything sound super bassy. Like I think the court reporter just like rolled her chair back and it was like blah, 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 blah. So we will have Whitaker for the final plea hearing for the remaining co-defendants in the YSL trial. So that's going to start at 9:30. And what we'll be doing, guys, is, you know, some things might overlap, but we'll get to all three things today, including Shannon Stillwell's plea/status hearing. And guys, also, speaking of Kayla, there is a very big WTF Wednesday tomorrow. It's a holiday party. I think you'll like some of the guests that are coming on, but can't say who they are. And no, I'm not like patting myself on the back. I'll be there, but I'm not talking about me. So let me get you the link to that. Make sure you guys hit that notify button. All right, and this is going to be at 6:30 p.m. tomorrow. And this is going to, again, be with Millionaire Mel and Miss Jefferson. So there's that link there in the chat.
Good morning.
Morning, Judge, how are you?
I'm fine. We will be taking the cases as they get people up. It's a little chaotic downstairs. So I'm not quite sure what the flow will be.
I can run downstairs at 9:30, just Whitaker's first, very brief.
I was told there's something in 1C, there's something next door, there's something in here that is of interest to lots of folks. I'm a little more focused on all the murder cases, but
My God, Judge.
So will you be handling all of the bond hearings? There's one add-on that is sex crime. Okay, I saw Ms. Clark kind of briefly in the courtroom and then she left.
Sure, there's a couple who have, I think there's 3 defendants who have murder counts, but also the cat cases, so she'll be handling those as well.
Okay, got it. Yeah, there's a couple whose kid OD. She'll do that. Okay, and then the add-on with, I think that's Mr. Tevis is handling that. Okay. Is she coming back here? All right. And on the defense side, sir, do you have the good fortune of handling all of the appointed cases?
Your Honor, as far as I know, I'm here for just Roger Powell. For the
Just one?
Yes.
Okay.
And I'm not sure that Mr. Powell will be brought up here. It's my understanding he's in Gwinnett County.
Oh,
That's there.
okay. Well, that'll streamline that one. Okay. And you are?
Attorney Year Sergeant.
Okay. But that's the only one you've got?
Yes.
Okay.
I will follow. It sounds like Adam has to go around from room to room today to do like the YSL plea hearing, and I don't know if he's got to be present for Shannon Stillwell's hearing, but we might be following him around. This is not a Kayla issue, guys. This is making sure all the defendants get up here, right? Don't forget they have to transport people that are in custody. And no, you haven't missed anything, Sleepy.
Will Mr. Rao be able to stay, will you be able to stay here if Mr. Abbate has to go to 1C, or you guys are there?
I'm sure we can tag team.
Okay,
Yeah, he can stay out on the later. That's what the kid.
okay. We'll see. Currently, we have no defendants.
Yeah.
Yeah, this sounds like a transport issue if they've got nobody.
Mr. Mursajan, do you have a colleague who will be covering? We have 10 bond hearings, and in reviewing them last night, a number of them look like they would be appointed counsel. I know there's going to be one conflict issue because it's co-defendants, but I'm surprised you have only one, and you're lucky if that person's not here.
To my knowledge, Your Honor, I haven't spoken with any other attorneys about needing to bond, but I can reach out. and-
Okay. Great. Who typically covers this calendar?
We just, the clients are assigned to us, based on when they have their first appearance.
Okay,
So I would have had, Mr. Powell today, so
You have it already? I have, but I don't have it together.
Gosh.
They have private counsel, my understanding, so I was going to give Mr. Powell. The other, defendants should have their public defenders as they were assigned to them.
okay, yeah, if you do a little outreach, that would be great. All right, are there any attorneys here for bond hearings for someone whose name is not Kendrick?
I guess
Yes,
they're
ma'am.
gonna.
You are here for whom?
I have Carl Washington and Darrell Eric.
So Carl Washington's been indicted and assigned to Judge Leffridge, so we will not be hearing bond for Mr. Washington today. What was the other one? Darrell Williams, I got that one. And you are? Can you say your last name again? Isola? How would you spell that? Okay, so once Mr. Williams is up, we'll try to do that one. Judge Leffridge, so that won't be heard today. That's just, he's been indicted, and so any issues or questions about bond will be covered by Judge Leffridge, to whom his case was assigned. So I don't even think he was brought over today. He may have been, but I won't be addressing bond because it's now assigned to a judge.
So big shout out to Tat Clouds here, stating the obvious. Miss y'all slimes. It feels weird. It feels weird.
Morning, Ms. Clark.
Morning, Art.
So you'll be handling the bond hearing or, assuming we get lawyers for Kuykendall and McCaslin,
Yes, sir.
as well as Mr. Tevis's client.
Tyreek.
Yes.
Robinson.
Yeah.
There's everybody's favorite guy. Look at the screen, guys. Look who it is. Oh yeah, I forgot we had shart stickers. A wild Max shart appears. Heck yeah. Oh yeah, Nancy knew one too with the recall here. Attorney Tevis represented Attorney Manettis when he was arrested for that prescription. Yeah, Cutie K, don't judge me by how I recognize people.
Pardon me?
I didn't receive a calendar for this date. I don't know about it because I looked up my concept, obviously. So I get a calendar for that to the splits.
Okay, let me get you a calendar. Ms. Nelson, can you text me to whom you sent the presiding bond calendar on the public defender side? Because it sounded like it might not have gotten over there.
I went to our team and so it
Meaning-
didn't go to any private attorney. I mean, it didn't go to the public defender's main office. It went to our team.
Meaning it went to Ms. Rios and Ms. Wood.
Correct.
Okay, I'll print you one.
Thank you. And additionally,
I got an extra copy.
Of the bond calendar?
Yeah.
Great, here it comes.
additionally, I did not file a bond motion for this hearing today, so I also need to see why other public defender attorneys are not aware or not here.
Huh.
This
Well, we shouldn't be calendaring things where there aren't bond motions. We're gonna need to work on our process.
Because my client has only been in custody for about 20 days and haven't even had the hearing yet.
Well, that's what all these are, though. These are the ones where there was a bond deferral. So at first appearance, because of your client's charges, murder, and all these other folks, with one exception where it's a child sex offense or a rape or something, they're all murder cases. And so they never got a crack at a bond hearing. And so we automatically put them on these calendars. But you can say no thank you at this point. There's not a mandatory bond hearing.
Yes, sir, that was my plan to, well, not exactly withdraw the motion, but say we're not ready for a bond hearing at this time.
Okay,
I'm just a path for that.
okay,
And I will reach out to the other attorneys and figure out.
okay. So I should take Powell off because you don't want to go forward with bond today. It'll stay with me. It's until indicted, bond hearing will be here. So if you want to defer the bond hearing to another day, that's good to know. I just want to make that notation.
Yes, sir, that's enough.
Okay, thanks. Yeah. We'll see, but that may make it go more quickly. Right, right. Okay. All right, so if there was anyone here for Mr. Powell and the deceased in that case is Mr. Woods, we're not going forward with that hearing today. And we'll see what other announcements we get.
It's so hard to like tell that they're not doing anything because the like random noise in the courtroom is so loud. Things are just banging around. And if you're just joining in, this is Judge McBurney. He's not visible. He's like over here off the screen. It is his YouTube channel.
What, I forget the attorney's name, but that seems to be the running theme of these, the positions today. There's no bond motions filed, like in, for example, Mr. Drinker, there's no bond motion filed.
Not even, sometimes there's just language to that effect with the first, when someone enters an appearance. I don't know what's triggering it, but we're gonna need to rethink our approach and just slapping everything down that got deferred for a hearing. And I think the default is you could not have had a bond hearing even if you asked for one. If you're Mr. Drinker, just using that as an example, because of the charges. Mr. Drinker, there are 2 decedents? Did I read okay. So, but that may explain why there aren't colleagues of Mr. Mursadin here, that they weren't planning on arguing bond at this point. That was streamlined today.
Probably why there isn't an attorney listed on the calendar either. There's
Yeah.
a lot of them there.
So,
Stand. That one we can do. He's one of the Powells, is Roderick Powell your client?
Yes,
Do you want to talk to him or
I can speak for everyone.
we're skipping? So he can go back to Roderick Powell. And we have a lawyer for Daryl Williams. Daryl Williams is here. Okay, so we can do that. Daryl Williams and Robinson Baker are the ones that are ready.
Adam's over there fanning himself. Everyone else is in like winter coats. David says, why do I feel like I'm going up for bail? Because it's just like that feeling of being in a courtroom. I'm not sure of the full list because they've already kind of pruned it, trying to organize things before they have their first person come up. So I don't know the number that's left. Shark getting right up there to the table. Look at him go. And again, for the YSL final
Do you
plea
have one
hearing,
of
there's
the-
5.
you're just a hanger on.
I'm a
That's what I thought. Okay. You got nothing to do these days.
Right, no, I'm actually next door. I'm next door, but yes, I'm looking for things to do.
Okay. I got some
Good to
things.
see you, Judge.
Yeah, let me know. Could do some trials next year.
Can I talk for a second?
Yeah.
He's just walking around. That's so great.
This might have been after your time. Did you ever go to University of South Carolina for the Trial Advocacy Center?
Oh, that's
Over
gonna
there
talk about
as a
football.
USA?
Yeah, a lot. That was where all our trainings were.
Right, right.
Yeah.
I went to school there, and last week when Victoria, she was a mock judge. They have the district court judges go down and help train, so.
Yeah.
All right,
so I
we've got
to
a
go back
defendant
down
ready.
there, and that was always on campus when I was there.
Yeah.
Towards the end of my time there, it was on campus,
Yeah.
but I never really took note of what it was. It was just
Yeah.
some fancy building that I
It
knew
is,
nothing
it's
about.
nice. Yeah,
Yeah, so.
yeah, because the residences are there and there's a
Right.
cafeteria and then all the classrooms.
Well, I heard the residences aren't that great. They put us up in a hotel right next to it called the Graduate. It was a
Yeah.
good time. So I got to take Hollis down and show them where I went to school and
Good.
everything. So it was
Excellent.
cool.
Your
Yeah.
family event.
Yep.
We've got Baker. Okay.
Yep, so as soon
Mr.
as Shart
Tevis,
gets called out for
you ready to go?
meandering, we
Ms.
have a
Clark.
defendant ready.
We're gonna do Mr. Robinson Baker. That's who we got.
Shout out to Max, keeping busy.
I'm just saying.
Let's see, do they have, is one crime up yet for the YSL plea hearing?
Yeah, that's.
Oh, and I'm gonna drop a series while they're getting set up here.
All
I'm
right,
going to drop a
Ms.
series
Rivers, are
of
you ready?
Twitters.
Okay, we're going on the record in 24 PI 008168. It's State versus Tyreek Robinson Baker. Good morning, Mr. Robinson Baker. I'm Judge McBurney. I don't think we've met before, but your case has been assigned to me just for bond purposes. The state may at some point indict you for what you were arrested for, and that'll be randomly assigned to some judge. It might come to me. Chances are it will go to a different judge. But as long as there is a question about bond in your case, then Mr. Tevis or Mr. Wolf, one of the lawyers working on your case, will bring that to me. So that's all we're working through today. Mr. Tevis, you are here on behalf of Mr. Wolf?
Yes, Judge.
Great, and we have Ms. Clark for the state. Mr. Tevis, I am ready to hear from you as to why Mr. Robinson Baker is a good candidate for bond and what that bond should look like.
Judge, you of all people are one of the are very well versed in the applicable case law that's going to be considered when establishing bond. But I would like to just go through 3 or 4 cases that have some pretty, I think, powerful language that is often forgotten in this building that I want to argue against the backdrop of that. So first of all, everybody's famous case in Georgia, Ayala, right? The purpose of a pretrial bond is to prevent punishment before a conviction and to secure the appearance of that person in court for trial. The most fundamental premise of our criminal justice system is that a person ought not to be punished for a criminal offense until and unless the state demonstrates guilt beyond a reasonable doubt. That is Vanderford versus Brand. In some limited circumstances, pretrial detention is permissible as a regulation serving a legitimate and sufficiently compelling government interest. And to that end, pretrial detention may be a permissible regulation rather than an impermissible punishment if it is rationally connected to a non-punitive purpose and is not excessive in relation to that purpose. And that is Carr v. State 303 Georgia 853 from 2018, which quotes United States versus Salerno. In our society, liberty is the norm, and detention prior to trial or without a trial is a carefully limited exception. And what that means is that the default position should be that a person is released prior to trial. That is the default position. We don't say this person has serious charges, they should stay in jail because they haven't proven, the state has not proven those charges beyond a reasonable doubt. The defendant is always going to be at a disadvantage. We do not have the benefit of discovery. We don't have any of the information on which the accuser gave to the police that caused the warrant to be issued in this case. And so with that in mind, I suspect, as in the many hundreds, if not thousands of bond hearings I've done, the state will rely heavily on the facts because the bond factors are favorable to Mr. Baker. He's 27 years old. He was born and raised in Marietta, Georgia. He went to Sprayberry High School. He graduated from high school in 2015. He worked throughout high school. He worked at a Wendy's. He also did deliveries for his uncle's trucking company. He has continued to work doing that part-time upon graduation, and also worked for FedEx, making deliveries and working in their warehouse. He did that until he was involved in an auto accident as a passenger in a FedEx truck and was injured. He stopped working there. He then worked for AQC Traffic Control, which does construction projects where they, divert traffic and make sure that that's a safe environment. He has a history of employment here in Georgia. He has strong ties here in Georgia. His parents are here in the back, if you could stand up. And his mother, I think, was in the hallway. She may not have had her ID because the media case, they're not letting us in.
Right.
But his family is here. They're in constant contact with our office. If he's released on bond, Mr. Baker would reside with them in East Point. I don't have a GCIC, but I am aware that he has one prior incident involving, I believe, marijuana, and there was a firearm in the vehicle, not his, but I believe that he either has a charge or was sentenced in that case. I'm not aware of anything else that would show that he's a danger to the community or risk of committing further felonies. On paper and in reality, he is very tied to the community. There's no risk of fleeing here. There's nothing that would indicate that there's going to be intimidation of witnesses or anything like that. In fact, a preliminary hearing was conducted. We have a transcript of the audio of that I've reviewed, and it was the opposite. The alleged victim in this case called him repeatedly, I think 12 or 13 times, and demanded that he provide money to her, and threats were made to him, but nothing in the other direction came out at the preliminary hearing. I can go into the facts of that. I'd rather not, because true to my word, I want to say that bond hearings are not about the facts of the case, but if the state is going to get into that, then I will come up and would like to rebut whatever those arguments are. But given his presumption of innocence, he is factually innocent. He is legally innocent. The Constitution of the United States and Georgia both require that we stand here right now, assuming he has not done the thing that is on the calendar. So looking strictly at those bond factors, he does qualify. He should be given a bond. And we would ask that that bond not exceed $50,000, even though that bond is going to require his community, his family, his friends, his extended family to pool their money together to be able to even make a bond under those circumstances. But there should be nothing, it is not required to be exorbitantly high just to ensure that somebody returns to the court. I mean, this is his community. So we would ask the court to take that into account when setting the bond.
But not a particular dollar amount?
I said no more than 50,000, Judge. I think, I believe that 25,000 would be appropriate. I know your background, having worked in federal court. I have clients with extremely serious, complex charges with life sentences at the end who are released without money that are allowed to come to court and turn themselves in. I wish we did that more at the state level, but I'm cognizant of the fact that the common practice is to set a high bond, which in all honesty is, enriching the bonding company, but I don't think that really it does any more to ensure that a client does or doesn't come to court.
Where would your client stay if he posted bond?
He would live with his parents in East Point. I can provide the address off the record.
Okay.
If we need to do
and
that.
that's where he was living before, or that would be a new address for him?
No, that's where his family lived then.
Okay.
Yeah.
The warrant for this was sworn out in June, and your client wasn't arrested for many months. Any insight into that gap?
I don't have information on that. It also came out at the prelim that the incident date was supposedly in March. And so I think there was one that was
May. It's May.
I'm sorry, there's a delayed outcry.
That could be, but
Yeah.
the incident date was May
23rd or something like that.
May 3rd. And then the warrant is in June, and then an arrest isn't until late. I'm just curious if you had any insight into the gap between June and November.
I believe that police were in touch with him, and I think that Mr. Wolf arranged for him to be turned in on that, but I don't have details as to why there was a gap in that. Obviously, it wasn't a situation where he's on the run or anything like that. I'm not sure if they were in discussions or talking to him, hey, we'd like you to come in and talk, and they were not effectuating the warrant because they were hoping that he would come in and speak with them.
Right.
But I don't have information that he was fleeing or anything like that.
Okay. All right.
Thank you.
Ms. Clark.
Short and sweet. Rebuttal from the state.
Oh, Ms. Clark, before you go, you will come on to tell you good morning. Ms. Jackson, how are you doing?
Oh,
I'm great. How are you, Your Honor?
I'm well. This was an add-on calendar that came out late yesterday, so I don't know if you had a chance to look up Mr. Robinson Baker's criminal history.
Yes, I do have it, Your Honor.
Great, if you'd share that, please.
Yes, sir. He has 4 cycles. The last arrest was August the 24th, 2021 in Cobb County for possession of marijuana with the intent to distribute and possession of a firearm during commission of a crime. He does appear to be on first offender probation in Cobb County for possession of marijuana with the intent to distribute and possession of a firearm during commission of a felony. That disposition date was February the 1st, 2023, and the term is for 5 years. He does have 1 prior misdemeanor conviction. It's in 2022 in Cobb County for a non-fingerprintable offense. Nothing in addition, Your Honor.
Thank you so much. Officer Evans, I wasn't going to be calling on you today, I didn't think, but do you know if there is a warrant in the system for Mr. Robinson Baker for his probation out of Cobb in light of this situation?
good morning, Your Honor. Yes, Your Honor, there is an active
I can't hear you. It's odd. You're not muted.
warrant
but
at this
can't hear
time.
you.
We hear her.
Your Honor? Can you hear me?
It's coming through to us, not them, I guess.
Your Honor?
Uh-oh.
Can you hear me, Your Honor?
Other people can hear you. That's peculiar. Some of my staff said they could hear you. but
Pull up
it's
the
not
YouTube
coming
feed,
into the
Bernie,
courtroom.
McBurney.
I don't know what that deal is.
He is on
But if you
active
just want to type in
probation.
the chat, whether there's a warrant, I'll relay that. He is not yet. He does have a warrant. Okay, thank you. That's what I needed to know. Appreciate it.
Ms. Clark,
Good morning, Your Honor.
good morning.
So to answer, I just wanted to start to answer your question about why there was a space in time from when the warrant was sworn out and then when the defendant was actually arrested. From speaking with Detective Shields, he's indicated that he had, in speaking communication with the defendant, he was trying to give himself an opportunity to turn himself in. After a few months, the defendant did not turn himself in. So that is when he went ahead and issued the fugitive warrant to have him arrested.
Okay.
So
And
that
Mr.
is-
Tevis said something about Mr. Wolf getting Mr. Robinson Baker to turn himself in. Your understanding is contrary to that, that he was given an opportunity to do that, but that's not ultimately how it played out?
Yes, Your Honor. That's
Okay.
not, so in lieu of that, that is why that you have the delay in the arrest there.
Okay.
And Your Honor, counsel opposite refers to, he is correct. A person is innocent until proven guilty, but we're not here for that. We're here for bond. And to address that, we're looking at the Ayala factors. Your Honor, the state wants to bring the first reason we feel that the defendant risk of flight. It seems that based on counsel opposite's information, he seems to have strong ties to the community. However, a threat or danger to the people. Want to point out the fact that the defendant does have a past DUI conviction. Have a past DUI conviction, as well as showing the fact that, bringing the court's attention to the fact that when he was out on bond in Cobb County State Court for the DUI arrest, he was subsequently arrested in Cobb County after that on 8/24/2021 for a drug possession charge, felony
One crime
charge,
has
Cobb
sound.
County Sheriff's Department. That is on cycle 2.
But no action yet.
That indicates, Your Honor, that the defendant fails to comply with court orders because he was on bond at the time. So I
All right,
wanted to
guys.
highlight that as well. Risk of committing.
We are going to swap over. I will drop the link if you want to continue watching the state argue against bond for this defendant, who I don't know if delayed outcry was just being said casually or if it's being used as the legal term, but typically I hear delayed outcry with someone who is young when something happens to them and they don't report it till later. But I think the attorney might have just been using delayed outcry to... He should have chosen a different term there, I think. But this is McBurney in the chat linking there if you want to continue watching that. We will come back to watch Yak, but we're going to check out the YSL plea hearing for the final co-defendants. Oh my God, it's quiet.
Filed into Mr. Eppinger's case, or Rule 22. It has never gone to our public information office, and if you look on our website, there are very clear instructions about how you're supposed to handle Rule 22. And you're not supposed to file it in the case, and you're not supposed to send it to chambers, you're supposed to send it to our public information office, and then they take it from there. But, I mean, I am aware of it, so just in the future, if you can try to do it the correct way.
Of course, I think my colleague filed that one, but.
Okay, well, yeah, you can blame it on your colleague, that's fine. But anyway, in terms
Court reporter's back.
I do not mind if you have and I don't even know if notice went to anybody or if anybody is going to have any objection. That's one of the reasons why it needs to be done a particular way. So I would have to find out when we have everybody here, but assuming no objection, you certainly may use your laptop. And if y'all have a still photographer ever, that's welcome. Any other kind of like feed can just go through the pooled camera. All right.
All right, so this is really, really quiet. But I promise it's all the way up.
So we'll just wait till we get everybody before we get started.
Oh, now they're waiting. All right, so I'm just going to update my banner to include all three things because we're going to be jumping too much for me to go and fix that. We'll continue to watch the state argue here. Guys, if you just turned your volume up, lower it a little bit because we're going to go back to McBurney's courtroom and it's going to be loud. So get over there, turn it down. I'm going to start it halfway. And it's still going to be significantly louder. His courtroom is way, way louder. So let's get this going.
Getting felonies pending trial. The defendant currently, based on my review of the GCIC, is currently on probation with Cobb County for a marijuana distribution charge as well as a gun charge. He had a total of 7 years. The gun charge, of course, was 5 consecutive, so he is still on probation for that. Based on my review of jail booking and Odyssey, it indicates that Cobb actually has a hold that they placed that says no bond on that. So I'm pretty sure that that is likely because of this arrest. There is a strong risk of intimidating witnesses, Your Honor. In this particular case, the victim knows who the defendant is. There's a young lady, Kim Yee, who actually was a friend of the victims at one point. She actually ended up coming over to the place where the incident location, where the assault happened. So these people know each other. And there is an intent to intimidate the witnesses. Ms. Head, the victim in this case, says she fears for her life and that she does not wish for him to have bond. She is actually has provided a statement to our victim witness advocate that she'll read for us. But this is a serious capital felony crime, despite counsel opposite's suggestion. It is the nature of the crime does warrant a no bond status. And that's what the state is asking for. We believe it's appropriate in this case because the defendant is currently on probation. He has shown that he does not comply with court rules as he has violated bond orders when he was actually on probation. And as I said, he's on probation for the drug marijuana with intent to distribute and the firearm charge out of Cobb County. I think that he has a high risk of intimidating witnesses because of the fact that there's a friendship between the female that was assaulted. I think the roommate or something was also, he knows the defendant. So there are a lot of people that the defendant would have access to. And so for those reasons, I think the bond should be denied.
All right, thank you, Ms. Clark. So, Mr. Tevis, you had asked to have rebuttal time. You certainly can have that. I'd ask you to include in there what more you can add, because I believe it was your client's father was sort of raising his hand on this issue of the delayed turn-in. That's getting more mysterious to me. And it's not dispositive here.
Sure.
I think the Cobb situation is for a temporary ruling that I'm going to make, but if you could clear up as best you're able, knowing that you're parachuting in as well,
sure,
what your understanding is with, hey, you should turn yourself in, I'm not turning myself in, however that played out.
Sure. My understanding is that the police were talking with Mr. Baker Robinson. They wanted him to come in, as I said before, make statements, talk to them. He was waiting to hire counsel. He also had some private family medical issue he was trying not to go in about. I've checked our records. Mr. Wolf was hired at the beginning of November. I know that they were talking and meeting with him in October. And so the last couple of months were, Mr. Wolf was talking to police about arranging a turn-in at the jail, which they did, and they surrendered to him.
So ultimately, there may well have been before, I'm gonna call it your firms, but before the collective legal involvement of you and Mr. Wolf and others, who knows, there may have been some back and forth, and the police may have perceived that your client was reluctant.
Right.
It's not like he's under an obligation, but
Of
he
course.
was reluctant. But in the end, the way that your client went into custody is that a lawyer escorted him to the county jail or wherever.
Correct. He was surrendered to Fulton County Jail.
Yeah, and the state's perspective is, gosh, that took a whole lot longer than it should have. If this is someone who was coming in to say, hey, let's clear this up.
Sure.
And I understand that, and that's a reasonable perspective. Anything else you wanted to add?
Sure. I could guess that probably part of the delay could have also been, if we're guessing, that police were just kind of lazy in this case. I mean, you can call someone and say they have to turn themselves in, but in reading the preliminary transcript, interestingly, that the state brought up, hey, well, let me back up on that. The buzzwords that I'm hearing from the state that I usually hear are, I think he's a danger to the community. We believe, the state always believes that, they always think that, and they always oppose bond. I mean, the credibility in the building, there aren't even cases where they consent to bond at first appearance, not even just serious violent felonies. And the state is correct that the court can and should consider the severity of the offense when setting bond conditions and the bond amount. But to say that the severity of the offense disqualifies from some bond is in direct contravention of Supreme Court precedent, Georgia statute, U.S. Constitution. That's just not the case. Iowa is a murder case. That's where we get all these good languages and everybody quotes it when in fact it's actually codified in the statute. So the charge itself is not dispositive. With respect to he knows people, so we think he's a danger, both of those witnesses testified for the defense at the preliminary hearing, contrary to what the victim alleged. They were both present. The victim, they said, called us and said, hey, are we drinking tonight? Can I come over? She showed up with an open bottle. She was pouring out, taking multiple shots, all of those things. That is not evidence that he is a danger in any way, shape, or form. Both of those witnesses testified that they were there, they didn't hear anything, they saw them together, she was cuddling in bed with him, all these things. So at the outset, even though the offense looks serious, there are various flavors of what this charge could be. Georgia has no degrees. Something that's ultra serious, violent, stranger on stranger is the same thing as people were drinking and they wake up and don't remember what happened. But that is not what was happening here. Both of those people that the state cited testified, were called by the defense under oath and directly contradicted what the alleged victim in this case said. So as far as the severity of the offense, the charge is very serious. As far as the strength of the case, we would contend it is not. And so far, he's still continuing to be incarcerated on a case that he's presumed innocent, in which we don't believe is a factually strong case for the state. So because of all of those things, we would ask that, again, the bond not exceed $50,000. We don't care if he's confined to an ankle monitor or even home confinement except for work, but he should not continue to be held in custody with no bond, given the light of he meets all the statutory factors. And again, the strength of the state's case at a fully drawn out preliminary hearing with an officer and witnesses was more favorable to the defendant.
Okay. Well, it wasn't, I guess, so favorable to the defendant. Judge Brooks still found probable cause to bind it over.
Judge, that's such a low standard.
But it's not that she said, I'm dismissing this charge.
Right.
Okay. All right. Is it Baker Robinson or Robinson Baker? I apologize if I was reading off the calendar I had. How do you say your last name?
Robinson Baker.
I got it right. Good. Mr. Robinson Baker, I'm going to leave you in a no bond status for just one reason, and it's a reason that can be addressed. You're on first offender probation out of Cobb. That's a delicate situation for you. This has come up while you're on first offender probation. Cobb has issued a warrant saying we need to see Mr. Robinson Baker to talk about what was going on in May of this year while he was on first offender probation for that marijuana and gun case. And I want to get you there so that can be addressed. Should that be addressed, And the only
They'll
thing
get
left
bonds here.
holding you in custody is this no bond situation. We'll reconvene and we'll have this conversation again. Your lawyers will have a little bit more time. They might be able to produce a couple of these witnesses that they were talking about. And your situation, I've heard about the stability of your work and your household situation and all that. I won't need to hear that again. But what has come up most prominently is that you actually have a warrant, and I need to make sure you get to Cobb. And so I'll do that. You and a lawyer in Cobb will figure out what the consequences are, if any, for having been arrested in this situation on your first offender probation. And once that's been resolved, you come back here and we'll revisit this question of bond, and there won't be that cloud of, wait a minute, I could give you a $1 bond right now and you don't get out. You would go straight to Cobb. And I want to have that dealt with, and then that'll be off the ledger and we'll figure out what kind of bond, if any, makes sense in your case. Any questions about that?
No, sir.
Okay, Mr. Tevis, anything else on behalf of Mr. Robinson Baker?
Judge, just questioning the mechanics of how we're effectuating getting to Cobb. Is just be some kind of transport order, because he'll have to be released from this hold to get to Cobb.
Right, we'll work with Cobb on that so that then there's a hold put back in place. But this, we've done this before where someone goes to a neighboring jurisdiction. If it was Pennsylvania, I wouldn't be comfortable that we necessarily get them back, but it's an adjacent county. And so we'll get, I'll work on the logistics of getting Mr. Robinson Baker there. And then I know you or Mr. Wolf or someone will let us know, hey, that's been resolved and he's back in Fulton. We need to address
There's a
this.
plea for Shannon Stillwell.
Ms. Clark, anything else?
No, Your Honor.
All right, thank you.
I don't have details, but Cathy Russon, well, Max Shart has announced that there is a plea deal in the
Do we
remaining case against
have-
Shannon Stillwell.
Do we have an update?
Yes, Your Honor, update on the defendant cases for this morning. I have been able to get in contact with the other two attorneys who should be here for their clients. That's Mr. Fazoli.
Okay.
He's presently in interview with Judge Brooks doing preliminary hearings, but said he'll be up here as soon as he gets a free moment.
Okay, so he does want to go forward on his cases.
My understanding is that Mr. Fazoli said he is ready for Hutchison, McCaslin, and Drinkard.
Caslin, now Drinkard, Drinkard. Okay, great.
And
Does he have a client where he's saying sort of like your client, we're not doing it today?
yes, that would be for Mighton and as well as Alvin Powell, position 5.
Okay, so Ruben Mighton, we will defer to another day. And you said Alvin Powell, number 5?
Yes, Your Honor.
Defer, got it. And then you said there was a third attorney.
Yes, one more, Jessica Jones, Attorney Jones, has Daryl Williams as position 1. She also, she's not ready, but she would try to.
There's a young lady back there who says she represents Daryl Williams. That was the name, I still didn't get it. She was way in the back.
Okay, Mr. Williams, firefighter.
Okay, and did Ms. Jones have anyone else, or that was it? So Hutchison is Cazzoli, and he'll be here. Kuykendall, we don't know. McCaslin is Cazzoli, and he'll be here. Alvin Powell, we're deferring. Drinkard is Cazzoli, and he'll be here. Mighton, we've taken care of. You're Roderick Powell. And then we don't know about Beatty, but that may also be the young lady.
Beatty, yes, I know the Beatty is firefighter counsel, I don't know if that attorney's here.
Okay.
And I can also say that Kuykendall is a co-defendant in the castle, so she would be
A conflict defender.
conflict attorney. I don't know if they got those to stop her.
Yeah, maybe not. So I'll at least let Ms. Kuykendall know we're not ignoring bond. We just, ma'am, are you ready to go on Daryl Williams? And did you say you also have Mr. Beatty?
Yeah.
No, just, oh, you had Carl Washington. Got it. So you've been retained by Mr. Williams or his family?
I am doing this hearing for bono.
Okay.
I filed a limited extra for the purpose of bond.
Just for bond. Okay, got it. Thank you. What do you want to do?
SB
We still don't
is
have
getting,
to-
he's taking a plea,
He's not up
not a
yet.
bond.
Okay, so if we got
Plea,
Williams,
plea.
why don't we knock that out? And then do we have, who else do we have up? So McCaslin will be able to do, we'll be able to do both those, just the lawyer's not here, so we should leave them up. That's it? Okay, then why don't we bring Daryl Williams out, at least make progress. Uh-oh. Number 5.
I'm laughing.
Number
Joseph
8.
Papp is like, Abbate has left the room. Abbate has arrived at Whitaker's courtroom. Abbate has arrived back in McBurney's room. Just getting updates based on the location tracking of Adam Abbate.
Yeah, but we don't do anything until someone makes that. We don't have to proactive. And the number 3 is a conflict. defender case. So, yeah, we can do that today. If she gets brought over, I'll let her know what the situation is.
Right. I don't know if I'm audible when there's like the background noise from this court because it's kind of loud, but we're still on the Georgia seal for the Whitaker courtroom.
All right, Ms. Rivers, are you ready? Okay, this is 24 PI 008200, State versus Darrell Williams. Good morning, Mr. Williams.
How you doing?
I'm okay. I'm Judge McBurney. I don't think we've met before, but we are going to talk about bond in your case. That's all we're doing today, just bond. And as long as there are bond issues in your case before it's indicted, that'll be in front of me. Once it's indicted, it's going to be randomly assigned. Could be me, could be a different. Now that you're closer to a microphone.
Last name is Isello, IASIELLO.
Iasello, Ms. Iasello, thank you for being here for purposes of bond. Mr. Abbate, are you handling this? Okay. Mr. Williams, you're charged with murder. You were originally charged with aggravated assault, and Mr. Clark passed away, so that was upgraded to murder. And I'm going to hear from Ms. Iasello why you should get a bond and in what amount. Then I'm going to hear from Mr. Abbate about what the state thinks about bond. Let me pause for 1 minute. Ms. Clark, you were going to give me a victim impact statement, but when we have another hearing on Mr. Robinson Baker, make sure you do that. All right, Ms. Iasello, when you're ready. I think it's easier for Ms. Rivers to hear you if you do that. Thank you.
Good morning, Your Honor. Thank you for the opportunity to present this bond argument on behalf of Mr. Darrell Eric Williams, a man who stands before this court accused of a serious charge, murder. While the charge is significant, Mr. Williams is presumed innocent, and the purpose of bond is not to punish, but to ensure his appearance in court and protect the community. We respectfully submit that Mr. Williams is not a flight risk, is not a danger to the community, and is not a risk of committing new offenses or obstructing justice. Under Ayala, these 4 factors guide the court's decision on bond, and the facts of Mr. Williams' case support the granting of bond. In addition, I must bring the court's attention to Mr. Williams' significant and urgent medical concerns. Mr. Williams suffers from chronic kidney disease, is a kidney transplant recipient, is diabetic, and also suffers from neuropathy. These conditions require regular medical care, specialized medication, and monitoring that the Fulton County Jail is ill-equipped to provide. Denying him bond under these circumstances would expose him to substantial and unnecessary risk to his health. Lastly, it is critical for the court to know that Mr. Williams is the person who called 911 during the incident that led to his arrest. This act of seeking help does not align with the actions of someone trying to flee, evade, or obstruct justice. Due to a miscommunication with responding officers, Mr. Williams was charged. We are confident that as the facts unfold, the charges will be reconsidered, but in the meantime, we ask that the court grant him a bond so he can receive the medical care he urgently requires.
Thank you, chat. Atlanta
The
News
first Ayala
is
factor
live
asks whether Mr.
with
Williams
Shannon
poses a
Stillwell.
risk of flight.
So sorry to Mr. Williams here, not that Mr. Williams, but we are going to leave this one. We're going to check out Shannon Stillwell. Let's see. I don't think this is actually... Maybe right here? It's not really showing us who's up at bat, but let's see. Do you guys know if Shannon's up, or are you guys just telling me this feed is live?
Court that she gave you a copy of her.
And if she electronically filed it, I don't doubt that.
Ability to reach out to the victim.
File from the non-complex attorney suggests, and then he.
Yeah, I don't think this is Shannon, guys.
On the 24th. Okay.
3K. So it was under judicial hold status for a little bit.
So we'll continue watching the one that we heard about. We'll go back to anything that's
The evidence clearly shows that he does not.
We know the context of this one a bit better.
Mr. Williams was the 911 caller and not a fleeing suspect. The most compelling evidence that Mr. Williams is not a flight risk is the fact that he is the person who called 911 and was not fleeing the scene, hiding, or attempting to avoid law enforcement. Instead, he actively sought help and remained present as officers arrived. As I stated, Mr. Williams' health condition makes it impossible for him to flee. He is a kidney transplant recipient and requires ongoing medical care, including strict medication schedules, metformin for his diabetes, and treatment for neuropathy. Any interruption to his medical regime could have catastrophic effects on his health. He has every reason to stay near his medical providers and avoid life-threatening risks of being on the run. Mr. Williams is deeply rooted in this community. He's the father of 4 children, 2 adult daughters, and 2 young boys. He volunteers with food distribution programs to give back to those who have less than him. His friends care for him so deeply that they reached out to me when they were unable to find him around Thanksgiving and subsequently located him on the inmate roster at the Fulton County Jail. I agreed to handle this hearing pro bono because I was moved by the love and concern of his friends who were desperate to help a man they described as thoughtful, generous, and kind. Mr. Williams has no history of failing to appear for court proceedings. He has shown compliance with all legal obligations and has no pattern of attempting to evade responsibility. The second Ayala factor asks whether Mr. Williams poses a danger to the community. Here, there's no credible evidence to support such a finding. Mr. Williams does not have a serious prior history of violence or any criminal history involving firearms or weapons. The court is not being asked to evaluate a person with a pattern of dangerous behavior. It's also worth noting that Mr. Williams is 61 years old and does not have a history of weapons charges. Mr. Williams' role as the person who called 911 is critical to this analysis. His actions show that he sought help, not harm. The fact that the charges rose from a miscommunication with responding officers should be carefully considered. If the court has concerns about community safety, Mr. Williams is willing to submit to restrictive bond conditions, including curfews or electronic monitoring and pretrial check-ins. As far as the third Ayala factor, risk of committing new offenses, Mr. Williams does not have a pattern of repeated offenses. His record shows that he has been a law-abiding member of the community. He does have a pending battery charge from July, but as that case unfolds, it will be clear that he was defending himself from attack. Mr. Williams' primary focus is his health. Managing kidney disease, diabetes, and neuropathy leaves little room for anything else. His medical condition creates a natural structure in his life that drastically reduces the likelihood of reoffending. If there's any doubt, like I said, he is willing to submit to restrictive bond conditions. And there's no indication that Mr. Williams would interfere with the administration of justice. He has no history of obstructing justice, tampering with witnesses, or evading legal obligations. And it bears repeating that he is the one who actively invited law enforcement to the scene and was not.
So sorry, we're cutting the context. I think we're getting Stillwell. I'm trying to listen.
Oh, okay. Not a problem. We have other cases.
Oh. Look at Max. Well, we got the Max appearance out of all of this. Maybe we'll see him in Whitaker's courtroom too. We'll get like the 3-for-1 today with Max Shart.
Go to position number 6, indictment 24 SC 001711 Beverly Range.
All right, so they're gonna do someone else first.
Is this run done? This post-trial position number 3, indictment 22 SC 185439 Aquila Carter.
Nope. All right, and we're caught up there.
All right, position number 4, indictment 24 SC 001756 to Sean Hodge.
Oops.
All right. Mr. Marquez, are you representing the state?
I am, Your Honor.
Okay.
Lil Quez? I mean, you know what I mean. We have a Quez DA, an ADA Quez. Also, back in McBurney's courtroom, Adam Abbate is arguing for the state against bond for the Mr. Williams that we were watching. Shout out to YSL Quiz in the chat. So let me know if you guys want to switch back over to that. We finally have someone appearing to do a plea, so this might take a while for them to get through the colloquy. So it's up to you guys what you want to watch. Yeah, go back to the old man. You guys are crazy. I promise as soon as I hear the name Stillwell or Jackson, whatever they use, we'll toggle back over.
This motion for bond for several reasons. The first being that the defendant does have 3 prior felony convictions.
Everybody's
making
invested
him
now
an
in Mr.
A and C
Williams.
recidivist, in the sense that if convicted after trial, he'd be facing a mandatory life without the possibility of parole sentence. Furthermore, the state would submit to the court that the defendant is a risk of flight due to the strength of the case in that Mr. Williams is seen on the ring camera waving a gun around after he shoots it through the door at the victim who was inside of his home, who was struck in the face and ultimately dies.
So that was what I was asking Ms. Iasello about. Mr. Clark is the decedent.
Yes, Your Honor.
Mr. Clark is in his home or he is in Mr. Williams's home?
Mr. Clark is in his home and
Meaning Mr. Clark's home?
Mr. Clark's home, yes.
And what you say that the ring cam video would show is that Mr. Williams would be outside the door, not of Mr. Williams's home, but outside of Mr. Clark's home.
That is correct.
And shoots into Mr. Clark's home.
That is correct.
Okay.
And actually shoots through the door and strikes Mr. Clark on the left side of his head. Ultimately, police are called and
Max
medical
just
attention
walks
is
back
attempted.
in
But
Belinda's
about
room.
20 days later, he does succumb to his injuries due to being shot in the head. So I would submit to the court that he is a threat or danger to people in the community in it, as he shot Mr. Clark through his own door, unarmed at the time, and posing no threat to the defendant, excuse me.
Ms. Iasello indicated that Mr. Williams was the one who called the police and that he stayed on scene. Is that your understanding of the facts?
He is one of 3 people who called the police. He is actually the 3rd individual who called the police. The first 2 described that Mr. Williams was outside of the doors of not only their apartments, it's a 4-unit apartment building or home. And he was.
Is Mr. Williams one of the 4 occupants?
That is correct, Your Honor.
Okay, so he's around his own space, may not have been his door, but it wasn't that he lived across town and came to this place.
Correct.
Okay.
Outside of their doors, screaming threats at all parties who were around and living in the apartment building. So 2 individuals called, 2 females called 911 indicating that, and that they saw Mr. Williams outside their doors and the door of Mr. Clark waving the firearm, and then heard a single shot. Mr. Williams did then call 911 and was incoherent, I guess is the best way to put it. He was under the influence of something would be what the state would submit to the court, and he indicated that someone had just shot his brother. And I can clearly state to the court that Mr. Clark is not Mr. Williams' brother. And he did remain on scene. Upon the officers arriving, he did admit to shooting Mr. Clark through the door. So I can agree with defense counsel as it relates to that. So based on all the factors, Your Honor, and all the totality of the circumstances, the state would submit to the court that at this time, Mr. Williams is not a good candidate for bond and should remain in the custody of the Fulton County Jail.
Do you have any information? I don't know that they'd be reaching out to you. I'll be doing some outreach about the jail's ability to tend to Mr. Williams's health needs.
I don't. I can obviously reach out to whoever needs to be reached out to. I neglected to inform the court as well. The incident that occurred that defense counsel had referenced that Mr. Williams was out on bond for. It was an assault from July of this year. It was actually an assault on the same victim.
Mr. Clark.
Yes, and there are eyewitnesses who watched Mr. Williams out of nowhere begin to attack Mr. Clark as he sat on the porch and was defenseless at that point as well.
All right, thank you. Ms. Iasello, I'll hear from you again. I forgot to ask Ms. Jackson from pretrial services about Mr. Williams's criminal history. It sounds like Ms. Jackson, Mr. Williams has some convictions. I'm curious how old they are, if they're from the 1990s or if they're from 2 years ago. What information do you have?
Okay, they're
A bit
from
of
the
shade to
90s.
the
Your Honor.
age.
He has 18 cycles. The last arrest was July the
We're having this
19th,
issue.
2000.
You're off. majority of them from the late 1990s. The most recent one is from 2002, the terrorist threats out of DeKalb County.
Okay. Ms. Nelson or Ms. Hansberry, can you call IT so we can figure out why we're not able to hear folks who have dialed in? It sounds like it's not just a probation issue. I mean, there's clearly something going on in the courtroom, but we weren't able to hear Ms. Jackson.
Wouldn't be a YSL's trial
Thank you.
day stream without tech issues
Can
in
you
the
hear me
Fulton
now,
County
Your Honor?
courtroom.
ISLO, I would like, with your client's permission, to be able to talk with the jail medical staff. They'll be more candid with me if Mr. Williams says, hey, you can talk to Judge McBurney about this.
Music? What?
Yeah, that's me.
Oh my gosh.
I don't, this seems different.
Having a little party in there in the
because,
Zoom.
like, it's clear, like we see.
It's not
little
lizard
microphone
walk.
Showing that it's receiving things, but it's not coming out of the podium. But you may be right. Oh, that was not working either. Okay, so they should swing. Thank you. So.
This really is fine with you.
Okay, and Mr. Williams, all I'm not trying to pry into your personal medical situation, but it's important that you get the care you need regardless of these charges. And I need to balance whether that can happen while you're in custody or if you need to be out on bond for that. So that's helpful, and I will reach out to the doctor who manages the healthcare at the jail. Was there anything, Ms. ISL, you wanted to add or respond to?
Your Honor, I've not had the opportunity to review the room footage, so I can't speak to the accuracy of the of counsel's characterization of that. But you know, I would submit that Mr. Williams was obviously in his home. He did not flee the scene. He is committed to fighting these charges and clearing his name, and I do believe he is a good candidate for bond.
Okay. Your entry is for bond. Is it as long as we're going back and forth about bond, or it was for today? Okay, all right. Mr. Williams, I'm not going to set a bond at this point. I need to talk with the doctor at the jail to better understand how the jail might be able to or might not be able to support your health needs. In the interim, I guess, I'm fine requiring the state to get the ring camera footage to you, even though you won't necessarily be the lawyer long-term. It's certainly helpful. They're not obligated to do that, but I often ask when the state is particularly reliant on something in a bond hearing to get that to the other side.
I would appreciate that, Your Honor.
Okay, great. Mr. Abbate, would you be able to get to Ms. Iasello the ring? Oh, he's gone.
Right,
Mr. Rao,
Whitaker's
would
back.
you be able to get the ring camera footage? I don't mean right now, but just in the next few days.
All right, so Whitaker's back, you guys. There is no activity in Belinda Edwards' courtroom.
But we have the counsel for everybody else, so we'll just go ahead and get started with the final pleas for those people. Are there any guilty pleas that are going to be tendered today by any of the attorney, any of the defendants?
We have a plea. Miles Farley's taking a plea?
All right, why don't y'all come on up to the podium, please?
Oh no. Not Miles Farley. That's so sad. Oh, that's gonna make me sad.
All right, Mr. Body, whenever you're ready.
I'm so sad about this. Look how skinny he
And everybody,
is.
I'm just gonna give a reminder to just use the mics. They're in front of you and they're mobile, so you can move them up close so that everybody can hear.
She's making a mic up.
USC 182, 183-572, State of Georgia versus Mr. Miles Farley. Farley, please raise your right hand. You solemnly swear and affirm that testimony about given the matters pending before this court will be the truth, the whole truth, and nothing but the truth, sir? Yes, sir. Hey, put your hand down. Could you please state your true, correct, and legal name for the record? I'll let you sign before I ask you all questions. Two things at once.
And Mr. Body, maybe reposition the mic while he's doing that.
Yes, Judge. Mr. Farley, could you state your true, correct, and legal name for the record? Farley. And Mr. Farley, are you at this time taking under the influence of any alcohol, drugs, or medicine? No. Is there any medication that you take daily or regularly that you have not taken today that would affect your ability to understand why you're here? No. And how old are you, sir? And how far have you gone in school? 26. I got a bachelor's degree. And are you able to?
Can you also speak into the mic, please?
26 and got a bachelor's degree. And so are you able to read, write, and understand the English language? Yes. And do you understand you are charged in indictment number 22 SC 183-572 with count 1, conspiracy to violate RICO, count 49, which is related to the homicide of Mr. Drinks, counts 50 and 51, which are both participation in criminal street gang activity, and then count 54, which is a possession of a firearm and the commission of felony. You understand you're currently charged or indicted with those counts? Yes. And do you understand that you have the right to plead either not guilty, guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial. Yes. And
Sorry, that's me buffering. I'm going to pause the other stream. We're going to keep going with this one unless you guys want to switch, but Yak and Kayla did just come out in front of McBurney, of course. And it's making me buffer.
Attorney Mr. Menendez gone over the rights that you're waiving by taking a guilty plea here today, sir? Yes. And are you satisfied with the services that your attorney has provided? Yes. And do you need any additional time to talk to?
All right, chat saying Yak.
About any of the facts and circumstances?
We will pause it. We will go back. We will watch the whole plea colloquy, but we're going to get Kayla and Yak.
Good morning, Your Honor.
Good morning.
And if you don't mind, I'm going to condense both the cases into one argument.
That's fine.
Okay. I'm just going to keep it short and sweet. As this honorable court, I'm pretty sure it knows, Mr. Kendrick has been in custody since May 9th, 2022. He has since been found not guilty on the charges that initially had him in custody. During those 2.5 years, he picked up these additional jail cases. The first case was picked up, as you stated, in April of 2023, the second in June of 2024. It is my understanding that Mr. Kendrick has 3 previous felony convictions, none of them being violent convictions. That is my understanding. And as we know, that is one of the factors in this court considering the bond. The second factor I'd like to address, which is extremely important to me, is community ties. And this is important to me as an attorney because Mr. Kendrick has family support. He has a lot of support. And not only are they here today, but they have been in court with him almost every day for the past 2.5 years. And I think that shows that he has a support system standing behind him. And he has a lot of accountability and responsibility to do the right thing if he's given the opportunity, given a bond. This is a jail incident, Your Honor, and I come before you a lot, and it's very sad to say, but normally when I pick up a client who I can't get a bond for immediately, that's a double client because they're gonna get a jail case. It's almost inevitable, and especially when you have been sitting in jail for 2.5 years for something that you essentially are found not guilty for. And had he not been there, this would not have happened. He has no reason, I don't even think he has an ability to contact the victim in this case if he is granted the opportunity to be given a bond. Also, I would like to talk about the aggravated assault, aggravated battery, and riot charges. I did not represent Mr. Kendrick, and he did not have an opportunity to sit in the preliminary hearing on this case, but there was a preliminary hearing held on this case.
When you say he wasn't able to sit in, he was in through Zoom or?
No, he was in trial, but the co-defendants were.
Okay, so there was a prelim, not as to him personally and directly, because he was in 1C.
Yes, Judge.
But in 2B, one floor up, they went forward with some or most of the other defendants.
Yes, Judge.
Okay.
And in that case, it's my understanding that the judge decided that there was, the facts did not arise to an aggravated assault, but a battery. And I know that, you know, the state can then go and indict it and do what they do, but I just wanted the court to know that. In the bond motion that I filed, I specifically stated the DOJ report that was issued in November of 2024. This is extremely concerning for me because my client knows this all too well because he was actually a victim of a stabbing on December 1st. And you are very familiar with how it goes when people are close to release and when people are in high profile cases, and there is a target on his back. And, you know, I'm not sure, but there are also some people who may not be very happy with the not guilty verdict in this case and what he has alleged to have been a part of, but found not guilty of. I don't believe Mr. Kendrick has any history of FTAs. I have watched him fight for his life for 2.5 years, and I can only imagine the resources it took to afford an attorney, to afford clothes, to afford everything that he had to do, but he still found a way to afford me, which means he takes this case serious, even though it's a jail case, which means me and him are gonna work together to make sure he's back at every court date and do what we have to do so that he can follow any conditions granted, given by this court. Considering the fact of everything, I'm asking the court to set a bond no higher than $20,000 on all the counts.
Talk to me about where Mr. Kendrick would stay. I don't mean a specific address, but with whom, what that setting would be, and what kind of work he would be able to do if he's going to be working when he gets out. And I know some of those are strange questions because he's been in for 2.5 years. So it's not like there's a job at this firm where he was working, hey, we held your spot for 2.5 years. But I trust you and he have discussed something about the structure that would be in place. And that would help me understand what Mr. Kendrick would be up to and not up to should he be released.
Your Honor, Mr. Kendrick was a recording artist and is a recording artist, and not just, our typical, I'm a rapper, but a real one. And as soon as he's released, I believe he's going to start back making music. And before this, and I have pictures ready to present if the court wants to see, but I'm an officer of the court, but he was coaching Little League, he was performing, he was being a valuable member of society until arrested for charges that he was found not guilty of 2 years later, as he sat in the Fulton County Jail. I do have an address, and I did speak with his mother this morning that I can provide off the record.
Sure.
And it is a complicated situation because he's been in custody, but they have been working hard since I filed this motion to find somewhere for him to go.
He would stay with his mother, or he would stay at this address that his mother was able to find for him?
At this address that his mother would, and that's something, if you don't mind, we can talk about off the record just because of the whole situation.
No, I don't mind, and I'm trying to be elliptical about it, but it's probably wise for Mr. Kendrick, while he's on bond for these 2 cases, that it not be a house that's shared by people with whom he allegedly associated in the underlying case. And so while if he does make bond, I encourage him to pursue whatever trade, and that could be music and whatnot. It's going to need to be in a thoughtful way where he is not bumping up against some folks that he might have in the past circulated with for all sorts of good reasons or bad reasons, but that landed him in the trial that lasted 2 years and kept him in custody for 2 years. And I don't think it's an unreasonable expectation to say, while you're on bond for 2 other matters, you're going to need to move in a different way and in different circles than you did before. And so that's the only reason why I'm asking. It's not for you to share publicly. It'll be 123 Main Street, and I'll be staying with this person. but those people need to not be people with whom he associated before, not because that's necessarily a forever condition, but if he is going to be on bond for these things, I think everyone needs a comfort level, and basically for his own safety, you're not going back to whatever life was before. And so I need to be comfortable that those guardrails are in place. So it may be, and I'll hear from Mr. Rao in a minute, that we need to have some email back and forth about what those conditions would look like, who can be around Mr. Kendrick, who he needs to not be around. And something as simple as you can't go to those studios, because those studios are ones where we read about them and it's a great music making place. And the next day there's a dead guy in the parking lot. And that has nothing to do with Mr. Kendrick, but he can't be in that kind of space. He needs to find a studio up on a mountain.
Well, Your Honor, I think that we're gonna be working on getting a studio in wherever he resides so that he can, take some time. He's been in the public eye for 2 years, so I think he wants to take some time to make some music and gather himself.
Okay. All right. I don't want to get ahead of it. Maybe that bond's not appropriate, but I wanted you to know that if I do set a bond, we may need to have some exchanges, including the state, about, well, what's that going to look like structurally, so that I know what I can put in the bond that's not sealed, because there'll be a bond order that says, here you go, but there may be certain things that are under seal for a good reason. So we can work through that. But your request is a $20,000 bond across the two cases.
Yes, Judge.
Okay. All right. I appreciate that. Let me see. I want to try again, Ms. Jackson. I don't have any reason to believe they fixed the technical difficulties. But could you pop your mic on and say hi?
Hi, can you hear me, Your Honor?
Okay, yeah, it didn't work again. It's not on your end, it's something happening here, because everyone who is not in court can hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time to fix it, that would be great. And I'll look in what's in the chat. Oh, okay. Thank you, Officer Evans. Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation and then I'll get the warrant out to everyone.
Yes, Judge. The defendant stands before you having been indicted on two separate cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator amongst 7 co-defendants who've also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Detrell Wembley, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder. You know the history of that. It's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's co-defendant, Thomas's lawyers, is that not all, and they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case. Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there the entire time. And by he, I mean the victim. The victim
Okay.
remained there.
Got it. Let me pause you for 1 second. IT thinks they fixed the situation. Let's try Officer Evans. Officer Evans, can you,
Yes, Your Honor.
look at that. It's better. Thank you so much. Thank you, Ms.
Yes, Your
Hansberry.
Honor.
All right, somehow that device's volume got turned down, but we're back. All right, so your view from a review, your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault, I'm gonna call it the assault case.
That's correct. And in addition to that, the sheriff's office had an opportunity to speak with Mr. Kendrick. And essentially there's a lot of commotion in the background because it's on a body camera footage. They were able to secure a statement from Mr. Kendrick and
Mr. Kendrick or from Mr. Wimberly?
Both, but with respect to Mr. Kendrick, it's essentially he's saying, what else am I going to do? It's about respect. They're stealing my stuff. I got to do something. So I would disagree with the assertions that this is just a battery. And I think I'm more than happy to share the photographs with the court, and then the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does in fact have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015. The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC, for which he was sentenced on February 22nd, 2017. And I do see at least a probation violation on 2020. There wasn't any further information as to why, whether it was a technical or substantive violation. Then on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 140116, and was convicted of 6 charges: conspiracy to commit aggravated assault, participation of criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as an AK-47 in a vehicle, where he and his co-defendant in that particular case were on their way to a rival gang member's territory to commit a retaliation assault based on some prior actions. And that is the statement of Mr. Kendrick himself to law enforcement during the investigation of that particular case.
Can you give me that case number again, please?
Yes, Your Honor. 15 SC 140116. And it does appear that he is on active probation for that particular case, having been sentenced to 15 years to serve 2 sentences, with the balance of the first 8 years on probation, with the remaining last 5 years being suspended. In addition to that, Judge, we believe the defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022 and this date, the defendant has at least 13 reported jail incidents while in the custody of the Fulton County Sheriff's Office. Of those 13 incidents, 10 are allegations of violence and 3 are allegations of possession of contraband. And those include the indicted cases before the court today, which the defense is seeking a bond hearing. And many of those cases, there are other witnesses that came forward, including the most recent one on December 1st, 2024, where the allegations that the defendant was stabbed. Well, he was stabbed, and according to what another witness said, both a correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And I guess from the inmate's perspective, he needed to defend himself. Not that I agree that he should have been in possession of a weapon in the jail, but those are the allegations that have been put forth in this particular case. In every single one of those acts, violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, have pointed him to being the perpetrator of the assaults. And so while I certainly understand everyone is talking about the conditions of the jail, Exhibit A is before you as to why it's unsafe. So, Judge, we're respectfully asking the court to deny bond. We believe that the defendant is a danger to the community, a risk to reoffend, and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence where the defendant was at the time.
Do you have any visibility into whether your office is going to be bringing other cases from these other incidents? And I ask not to press or speed anything, but more so for a management, frankly. I mean, Ms. Bumpus needs to know what she and her client are up against. And I know that your office exercises discretion and doesn't indict every little scuffle that happens at the jail. Is it safe to assume that your office has filtered through that and we've got the two cases, the contraband and the assault? Or what's your sense? I know you're not committing the office, you're not in that unit, but you do have some managerial perspective.
From my understanding, Judge, there is one unindicted case that's been brought to our office. So I'm going to take a look at that and make a determination. With respect to the other ones, without committing anything to the court, I don't believe we'll be going forward on any of those.
Okay, so they would be at most, if Mr. Kendrick would go to
That's work
trial,
behind
could
the
be
scenes from Kayla.
404B, or could be linked to one of these other situations. Or it would be something in aggravation at a bond hearing or at a sentencing hearing.
That's
Is
correct.
your best forecast, with maybe one exception.
That's correct.
Okay, all right.
Thank you.
Thank you. Ms. Bumpus, want to give you the last word. I'm gonna not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention.
And
certainly
I'm going to pause here because you guys are saying child support in the chat. DCS is community supervision. So that's the DCS warrant. That's what McBurney's like, I got to look into that warrant that we just found out about. That's community supervision, not child
I
support.
want to understand that before I do something on this.
Yes, Judge. And it is my understanding that the allegation of the likelihood of reoffending, I just want to revisit that because the last time that my client committed a crime was in 2015, 10 years ago. And well, minus these jail cases.
Right. I don't know the federal one. It sounds like that was resolved in 2017, but that doesn't mean it wasn't 2014 conduct.
Your Honor, it's the feds picked up this state case. So they're not two separate crimes.
Got it.
This 2015 is the federal case.
All right. So there just was dual sovereigns and Mr. Kendrick got squeezed in both places.
Yes, Judge. So not two separate acts. And in me saying that, I don't know if this brings any or can help us get clarity on the warrant because my client's understanding is that the federal probation then trumped the state probation and he was to be reporting to federal probation because they had taken over this case.
Well, I don't think legally it would be that the state probation goes away. There's supervised release. That's what they call it on the federal side. And it may well be that Mr. Kendrick had a very clear understanding with DCS, state probation. Hey, you report to those federal folks. But that doesn't mean there wasn't a probation clock ticking and running throughout. And so what's been brought to my attention is that there may be a probation warrant situation as a result of these two cases. So as is par for poor Mr. Kendrick, everything's all connected. And so it may be deemed a violation of his state probation from the 2015 case that he got mixed up with having contraband and was allegedly part of the assault of Mr. Wimberly. And you know that's how it flows. And so if that warrant is out there, then we need to work through that and setting a bond doesn't make a lot of sense until that warrant is addressed. You know full well, once that warrant is addressed or if it's lifted or it's dismissed, or I don't know that judges tend to set bond on probation warrants, but if so, then we don't need to reconvene this session. I'll know that that warrant's out of the way. And then it does make sense to think about what a bond would look like for Mr. Kendrick for the two cases for which you represent him. If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter, or is this our universe, the assault case and the contraband case?
Okay, Your Honor, and just in closing, I just wanted to reiterate for the record that those two, the federal case and the state case, are one occurrence.
I got it.
And that the additional alleged acts in the jail, I mean, he has not been charged with those.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for? Because fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up? And it may be 3 accusations and 2 indictments, but whatever the state's going to do, don't do it piecemeal 3 months later, and then 3 months later, and then 3 months later for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state. But what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff and you need to decide what you're going to deal with. But it doesn't help anyone to just keep bringing you and Mr. Kendrick back. It's like, all right, and this time it was a cell phone. This time it was a cheeseburger. Let's just wrap it all up if that's what's going to happen. And I trust Mr. Rao is going to look into that. And they typically don't get every cheeseburger case. You get written up at the jail, but then as you hear about it, that's when someone says, oh, he was a saint when he was in jail. They said, well, not so much. He was a saint who ate cheeseburgers. Okay. And we worry whether that's a big deal or not. The big deal right now is the possibility that there's this warrant, which makes bond moot in these 2 cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015 because it would be that state probation. Okay. Mr. Kendrick, do you have any questions for me about what we were discussing? I'll make sure good lawyer, she's going to explain it all to you, but there's a chance right now, not about the facts of your case. Don't tell me I wasn't the guy who did this or that, but about the process we've been discussing.
I pretty much understand everything.
Okay. All right. Well, Ms. Bumpus will explain whatever you don't. And we will reconvene. I don't know that we'll necessarily have to have a full-blown hearing once we clear up this warrant situation. If there is a warrant, then I'm tabling bond on these 2 cases for now. If there's not a warrant or it's lifted or something, then I'll need to have a little bit of that offline discussion with you, Ms. Bumpus, and Mr. Rao about where Mr. Kendrick would be and how that would be structured. So I can see if I'm comfortable that there's a set of conditions that would keep Mr. Kendrick safe and also keep him out of the kinds of things that he needs to stay out of until he resolves these 2 cases.
And Your Honor, how am I gonna, can someone email me about the probation? Or
I will keep everyone in the loop.
Okay, thank you, Judge.
All right, Mr. Rao, anything else from the state?
Yeah.
All right, for those of you who were here for Mr. Kendrick, thank you for being here. I'm sorry you had to give up your phone. You'll get it back when you leave.
And Your Honor, that concludes my business. May I be excused?
Yes, ma'am. Thank you for being here.
So I'm just going to say you guys are welcome to have your opinions, but Kayla argued exactly what she needed to argue, that warrants out of state. So the criticism that how do you not know that your client had a warrant? It was from out of state. So I think that criticism is unfounded. It also might be a new warrant. And it seems like with Judge McBurney, I mean, they have to talk about conditions, but it seems like a bond will be granted if this warrant is nothing to deal with. When there is a warrant, an outstanding warrant, we saw it with one of the clients we watched earlier, one of the defendants we watched earlier. They can't just release somebody that has an active warrant for another matter. So, but if that's off the table, seems like Judge McBurney is going to work out a bond for Deamonte Kendrick. So, I think let's check Belinda Edwards' feed. Not sure if we've had, because I saw Max. Did you guys see Max like walk across the courtroom while I think the state was making their arguments here against bond for Deamonte Kendrick? Let's see.
And the state is represented as well. We also have indictment 22 S.
Hold on, let me
for
rewind.
Shannon Jackson.
And also, I don't know if you guys caught it, but Judge McBurney and the state, there were 2 other matters that Kayla already got resolved behind the scenes before they had this hearing today.
22 SC 181814 Shannon Jackson. His attorney is present and the state is represented as well. We also have indictment 22 SC 185532 and indictment 23 SC 188183.
Your Honor, before we get started, may I approach with something off the record?
State has to approach as well.
I think we're caught up to real time. We'll hang out for a little bit and see if they like, oh, I broke it. Let's just refresh it. Hello, YouTube. And guys, so for Miles Farley, and we'll watch that whole hearing. Here's Kayla. Look, there you go, chat. Kayla's back. Miles Farley took Alford plea on count 1. Everything else was null prost. Count 1 being RICO. And no, so this is not, let's get it straight, guys. It's not no bond for Yak. There's a warrant from Department of Community Services from out of state that's holding up an issue, but everything else is tidied up. And Judge McBurney, as he looks into this warrant, if that can be resolved, if he learns more about that, bond is on the table for Deamonte Kendrick. So.
He probably is, he probably going to
The world is on fire. This isn't unusual about warrants. And I think this is probably what it is, Melissa. Non-reporting while he was in custody. So it's out of state, and it seems to be from a Department of Community Services, like supervision, community supervision.
He missed us.
Also, my bad on the chats. We've been jumping around a lot today. Thank you again to Tac Clouds. Shout out, super late here. Thank you, Nisi, for becoming a new member. Asia Mullen for being a member for 3 months. That's 90 days. That's a long time. Christine Covey says half a pregnancy later. Shout out to Christine. And Christine says shout out to the mods and Kat. Thanks so much, Christine. I feel like I just heard Adam Abate's voice. Renee Stevenson with the kind. Good morning, Cat mods and the chat. Good morning, Renee. Peter Ortiz says, missed you, Cat. We miss you too. Perfect time of year for Lucy in the Santa hat in your picture. Touche says morning all, and it's still morning, so I'm not that late on these. Nice to reunite for a bit. For real, it's been a change of routine not having the morning trial streams every day. It's been a little bit of an adjustment.
Might see the cold cup of water. Is that okay?
We're back on the record. Bring the defendant, Mr. Jackson, out, please.
And this is a plea, you guys, not bond. This is a plea.
Good morning, Mr. Jackson.
Good morning.
As you stand before me today, you are here on 3 indictments. Indictment 22 SC 181814, Indictment 22 SC 185532, Indictment 23 SC 188183. My understanding in consultation with the state and your attorney is that we have a global resolution to all 3 cases. Is that correct?
That is correct, Your Honor.
All right, and you're going to be entering a plea of guilty to certain charges in these 3 indictments. So if you will you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
I need for you to tell me your name and spell it, please.
Shannon Jackson. SHANNON
Okay, put your hand down. Now, Mr. Jackson, the state has a series of questions to ask you. If you can, answer yes or no. If you need an explanation before giving an answer, let the court know and we will provide you with an explanation. If you need to speak to your attorney before giving an answer, let the court know and we will give you an opportunity to speak to your attorney. Do you understand?
Yes, ma'am.
All right, thank you. The state may proceed.
Thank you, Your Honor. Mr. Jackson, at this time, are you under the influence of any alcohol, drugs, or medicine that would negatively impact your ability to understand today's proceedings?
No, sir.
And how old are you?
32.
What's the farthest level of education that you've gone?
9.
Can you read, write, understand the English language?
Yes, sir.
And you're a little soft-spoken. Do you mind speaking up a little bit for Madam Court Reporter? All right, now do you understand that you were charged in case number 22 SC 181814 with possession of a Schedule 5 controlled substance, possession of a firearm during commission of a felony, possession of a firearm by a convicted felon?
Yes, sir.
You understand the maximum possible punishment on the possession of a Schedule 5 is up to 3 years in confinement?
Yes, sir.
You understand the maximum possible punishment on possession of a firearm during commission of a felony is up to 5 years, which would have to run consecutive?
Yes, sir.
You understand the maximum possible punishment on possession of a firearm by a convicted felon is up to 10 years in confinement?
Yes, sir.
Now, you're also charged in resolving today case number 22 SC 185532, in which you were charged in count 1 with serious injury by vehicle, count 2 entering auto with intent to commit a felony, count 3 theft by taking, count 4 failure to maintain insurance. Do you understand that as to count 1, the serious injury by vehicle, you could be sentenced up to 10 years in confinement?
Yes, sir.
Do you understand that for the entering auto, the maximum possible punishment for which you could be sentenced is up to 5 years in confinement?
Yes, sir.
And do you understand that for the theft by taking, based upon what the amount alleged in the indictment, that being greater than $5,000, less than $25,000, the maximum possible punishment for that offense could be up to 10 years in confinement?
Yes, sir.
And do you understand that count 4, the failure to maintain insurance, is a misdemeanor punishable by up to 12 months in confinement?
Yes, sir.
Now, as to case number 23 SC 188183, you were charged in counts 1 and 2 with participation in criminal street gang activity, count 3, possession of methamphetamine with intent to distribute, and counts 4 through 8 with possession of prohibited items by an inmate. Do you understand that for those counts 1 and 2, the gang activity, you could be sentenced up to 20 years in confinement?
Yes, sir.
Do you understand for the possession of methamphetamine with intent to distribute, you could be sentenced up to 30 years in confinement?
Yes, sir.
And do you understand the maximum possible punishment for each of those possession of prohibited items by an inmate is up to 5 years in confinement?
Yes, sir.
Now, do you understand that you have the right to plead either guilty or not guilty to any and all of these offenses? And if you pled not guilty, you would have the right to a jury trial in which the state would have to prove your guilt beyond a reasonable doubt.
Yes, sir.
Now, as your attorney, going over with you this form that I'm holding, the plea of guilty, acknowledgement, waiver of rights.
Yes, sir.
I
remember.
All right. And did you have an opportunity to review this form, go over this form in its entirety, and do you understand this form?
Yes, sir.
Now, Mr. Sharp, are you waiving any potential defects in this indictment on behalf of your client, as well as formal reading of the indictment?
So waived both.
And Mr. Jackson, do you need any more time with Mr. Sharp? Are you prepared to move forward at this time?
No, sir.
Now, in relation to this particular case, I believe you've been arrested on all of these offenses. Do you understand that if you enter this plea, that this also can be used in the future? It's what we call recidivist punishment, which means that if you got in trouble down the road, a court could look and see these convictions and therefore go ahead and sentence you to something greater than it normally would. Do you understand that?
Yes, sir.
You also understand there can be what we call collateral consequences to this plea. What I mean by that is that this can have a negative impact on, say, your ability to vote, your ability to have gainful employment, things of that nature.
Yes, sir.
Mr. Jackson, are you a United States citizen?
Yes, sir.
And do you understand that this is a negotiated plea of guilty?
Yes,
which means that your attorney and I in the state have come to a global resolution. We're going to go ahead and propose that to the court, and the court can choose to accept or reject that. However, if the court chooses to reject it, it could sentence you to something greater than what is negotiated. Do you understand that?
Yes, sir.
Now, do you also understand that if you were under probation or parole, that this can have a negative impact on your probation or parole status? And to be clear, this would not have a negative impact on the offense for which you just were sentenced, as all of these offenses occurred prior to entering this plea. Do you understand that?
Yes, sir.
Now, do you also understand that because this sentence will also include provisions of probation, that you will have to comply with all of those terms of probation, which also would include not possessing a firearm?
Yes, sir.
You also understand that possession of a firearm, aside from a probation violation, also would act as a new offense as you are a convicted felon?
Yes, sir.
Now, do you also understand that there can be, let me get there. Do you understand that you're waiving any and all offenses, including any mental health defenses, by entering into this plea of guilty?
Yes, sir.
Now, do you understand? I'm going to read off a list of rights here. At the end, I'm going to ask if you understand you're waiving all of those rights, okay?
All right.
Do you understand that by entering this plea, you're waiving the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to assistance of counsel hired by you, or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
I understand.
Now, has anyone forced you, threatened you, or promised you anything to get you into entering into this guilty plea?
No, sir.
Now, your attorney has worked out certain cases in which, and certain counts in which you're entering a plea of no contest, as well as Alford v. North Carolina, okay?
Yes, sir.
So I'm gonna go over each of these indictments specifically as to the counts. Do you understand Alford v. North Carolina is a situation in which you're not admitting that you are in fact guilty? However, you do recognize that it's possible a jury could convict you, and therefore you believe this is in your best interest to go ahead and enter into that plea. Do you understand that?
I understand.
All right, so we're going to begin with case number 23 SC 188183. Do you understand you'd be entering a plea of no contest as to the participation in criminal street gang counts, which is 1 and 2?
Yes, sir.
Do you understand you'd also be entering a plea under Alford v. North Carolina in counts 3 through 8, which is the possession of methamphetamine with intent to distribute and the possession of prohibited items by intent?
Yes, sir.
Now, do you understand as to case number 22 SC 181814, your attorney has requested, and the state is not objecting, to an Alford plea as to the count 2, possession of a firearm during commission of a felony, and count 3, possession of a firearm by a convicted felon?
Yes, sir.
And then that your plea would be a plea of guilty as to counts 1, 2, 3, and 4 on the 22 SC 185532, that being serious injury by vehicle, entering auto with intent to commit theft. I apologize, you know me, I'm a lawyer. By taking failure to maintain insurance.
Yes, sir.
Now, Mr. Sharp, understanding that you negotiated these with other attorneys and sort of standing in place, could I fairly accurately summarize the counts for which are the no contest as well as the offer?
Yes, sir.
All right, understanding all of that, how do you wish to enter your plea?
Guilty.
All right, and could that be guilty as to on the 22 SC, the serious injury by vehicle, the entering auto with intent to commit felony, theft by taking and failure to maintain insurance, is that guilty?
Yes.
As to the 22 SC 181814, which is the possession of a controlled substance, the possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon, as to counts 2 and 3. Is that under Alford v. North Carolina?
Yes.
And then count 1, the possession of a Schedule 5 controlled substance, is that guilty?
Yes.
And then as to 23 SC 188183, counts 1 and 2, the participation in criminal street gang, what is your verdict, or what is your plea?
No contest.
And the counts 3, possession of methamphetamine with intent to distribute, and then the counts 4 through 8, the possession of prohibited items by an inmate. What is your plea?
Guilty on the Alpha.
And is that plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand you would have only a limited right to appeal this guilty plea conviction?
Yes, sir.
And do you understand that for the felonies, you would have up to 4 years from today's date is to file what we call a habeas corpus, and that's if you wanted to challenge the constitutionality of this plea?
Yes, sir.
And do you understand that there is one misdemeanor on here, which is the failure to maintain insurance? Do you understand that you would have up to 12 months from today's date to also file the habeas?
Yes, sir.
Your Honor, I'm going to go ahead over what the factual basis is at this time for each plea, if it pleases the court. Judge, I will begin with the serious injury by vehicle case, which is the 22 SC 185532. Had this case proceeded to trial, the evidence would show that on June 7th of 2021, law enforcement responded to a motor vehicle accident on I-85 at Metropolitan Parkway, that location being inside of Fulton County. Judge, it was determined that this defendant was the at-fault driver in a motor vehicle collision that did result in the victim sustaining a fractured arm. Judge, there was a bystander that attempted to render assistance. Mr. Jackson then did leave from the scene in that bystander's vehicle without permission, that vehicle being greater than $5,000 but less than $20,000 in value. Judge, the defendant also did not have valid insurance at the time of the motor vehicle collision nor the departure from the scene. Judge, as to case number 22 SC 181814, had the case proceeded to trial, the state would show that on October 27th of 2020, law enforcement with Atlanta Police Department responded to an address on Judy Lane, which is located inside of Fulton County. They responded to that location because the defendant was parked inside of a driveway where he did not reside. Upon approach, law enforcement observed what appeared to be a prescription bottle. Judge, a canine came around and positively tested, positively alerted as to contraband inside of the vehicle. The defendant was a convicted felon at the time. Law enforcement was able to locate a loaded firearm inside of that vehicle. Judge, in addition to locating promethazine, which was the Schedule 5 controlled substance. And Judge, finally, as to case number 23 SC 188183, while the defendant was at the Rice Street Jail located inside of Fulton County on March 29th of 2023, law enforcement conducted a search inside of his cell. A judge, that was a shared cell, and located inside of that cell included a cell phone, the pills that tested positive for methamphetamine. Judge, the quantity would be consistent with the intent to distribute, as well as a shank, which is often used in either self-defense or to be the initial aggressor or primary aggressor, depending upon what day it is at Rice Street. And Judge, possession of Apple AirPods and an iPhone as well. Judge, I'll begin with what the negotiated recommendation is on case number 22 SC 185532. That's the serious injury by vehicle. Judge, the state's recommendation on count 1 is 10 years to serve 3 years. However, that 3 years is commuted to time served. Count 2, the entering auto with intent to commit a felony, is 5 years probated to run consecutive to count 1. Count 3, theft by taking, is 5 years probation to run concurrent with count 1. And count 4, the failure to maintain insurance, is 12 months confinement commuted to time served. Judge, as to case 22 SC 181814, possession of a controlled substance, that judge recommendation is 3 years commuted to time served. As to count 2, that would have to run consecutive to count 3. So count 3 would be 10 years probation, and count 2 would be 5 years probation to run consecutive, for a total of 15 years probation.
I believe my understanding of the recommendation was that was going to be 10, the count 2 was going to be 10 to serve 3 commuted to time served, balance on probation,
Yes.
as opposed to 10 years probation.
I will defer to you as
Big
you were the
difference.
one actively involved in negotiations on this one, Mr. Sharp.
Okay, so if you just go over those again for the record, for count, for 22 SC 181814. Count 1,
Is possession of controlled substance, that would be 3 years commuted to time served. Count 2 would be 10 to do 3 commuted to.
You can't do that if you're gonna do count 3, because count 2, possession of a firearm during commission of a felony, is a mandatory consecutive. So you would have to have count 3, the possession of a firearm, at some period of time, so statute minimum of 1.
Okay.
So if we're gonna get there, man.
I don't have the indictment in front of me. I think what I meant to say is count 3. Count 3 would be 10 to do 3 commuted to time served, balance probated, and count 2 would be 5 years probation consecutive.
Correct.
The difference, Your Honor, is him essentially receiving a sentence of 12 years probation versus 15 years probation. The intent is it would be 12 years probation because he's already served those 3 years.
all right, so let's be clear. Count 3, 10 to serve 3 commuted to time served, balance on probation. Count 2, 5 years probation consecutive to count 3.
Yes, sir.
Yes, sir.
And count 1, 3 years to serve commuted to time served.
Correct, Your Honor.
Yes, Your Honor.
You may continue.
And as to case number 23 SC 188183, as to counts 1 through 8, they all would be a concurrent 5 years to serve 2 years, the 2 years commuted upon time served. Judge, there are specific conditions that would go with these cases. Specifically, Judge, there was a negotiated from the trial division for a banishment from Metro Atlanta area as a condition of this sentence. He is to maintain gainful employment while on probation. There be no contact or communication, either directly or indirectly, with any named co-defendant in the case number 22 SC 183572. There is to be no contact or communication directly or indirectly with any persons associated or affiliated with a criminal street gang. And there is to be no possession of a firearm on his person in any vehicle in which he occupies, nor any residence, quite frankly, just no possession of a firearm, given he would be a convicted felon. Judge, I also understand, and Mr. Sharp had approached me about concerns about being able to travel through the Atlanta airport. There would be no objection to an exception for the Atlanta airport. Judge, this is the only case that was assigned to my unit, and I believe it actually was initially with the high-profile unit, was the gang case. And so, Judge, I do want to clarify for future cases why I am consenting to a no contest on counts 1 and 2, as it's not something I typically do, as this court's aware. Judge, the reasons for that is taking into account the working relationship I've had with Mr. Sharp over the years, who reached out to me along with Ms. Bumpus to try to resolve this case. Judge, understanding that there is multiple cases here, so I did not want to run into a situation where Mr. Jackson, who's had some incidents, unfortunately, at the jail, was remaining in jail while we litigated whether or not we were going to be dealing with a no contest on this case. And that is because also in this particular case, the typical negatives of a no contest plea for the prosecution are not present. Specifically because he is already a C recidivist, this is irrelevant, frankly, whether or not we would be able to have three convictions in the future. Judge, understanding as well that the negotiated terms of the larger sentence include provisions of no criminal street gang activity, as well as the negotiation of banishment. Judge, I believe that that is a fair trade-off in taking into consideration the banishment provision. And Judge, from a factual basis as to this particular case, Judge, we are running into a situation, had this proceeded to trial, that this was in fact a shared cell. Judge, it's been in the past occasions where other individuals' contraband can in fact be found in other individual cells, as well as the fact that there was a shared cell, so there was other individuals that would have had access. And Judge, in this particular case, I have not been made aware of any cellular dump in this particular case. Had a cellular dump been done in this case, and I've been provided with that, that would have demonstrated possession or control or intent over the narcotics or objects inside of that cell, we probably would be in a different situation. But I am not going to hold Mr. Jackson at Rice Street or ask him to be held at Rice Street while we did a cellular dump in order to ascertain that if we have a resolution that appears to be amicable to all parties. So just for future no contest cases, I wanted to be able to distinguish Mr. Jackson from other defendants that maybe argued were similarly situated.
All right, thank
That was basically, I don't usually do this, but
you. So will you go over the special conditions again so I can make sure I have them correct?
Yes, Your Honor. The special conditions would include banishment from the metro Atlanta area with exceptions for the Atlanta airport. Judge, that would also include that he has to maintain gainful employment while on probation. There is to be no contact or communication directly or indirectly with any named co-defendant in the 22 SC 183572 indictment. There is to be no contact or communication either directly or indirectly with any persons associated with a criminal street gang, as well as a no possession of a firearm. I do understand it may take a little while for him to be able to sort out the interstate compact, Judge. So there's going to be a sort of a grace period, at least from the state, in relation to him being in Fulton County until he's able to go ahead and work that particulars out with probation for the interstate compact.
Because another jurisdiction has to accept him as a probationer, correct?
That's correct.
All right. Anything else?
Nothing from the state at this time, Your Honor.
All right, anything from defense?
Your Honor, I would just like you to know that Mr. Jackson is 32 years of age. His father is present here in court. His father works an honest job for an honest living. His wife is also present in court, supporting him. He has 4 children. And so a lot of these past acts involve selfishness, immaturity, and I believe that Mr. Jackson, throughout this whole legal process, has come to realize how valuable life is, and we only get one. And I think he wants to make everyone proud. all the supporters proud and the people that have been here for him proud. So I know that he knows that he has people in his corner, and we're hoping, if Your Honor accepts this plea, we're hoping that this is something that we can all look back upon and say that this had a happy ending.
All right, so I have a couple of questions regarding the banishment. It's my understanding that he's from the metropolitan Atlanta area.
He is, Your Honor.
Okay.
He's lived here his entire life.
All right. So are there special circumstances under which he would be allowed to return during the period he's banished? Did the state negotiate?
Judge, again, that was a negotiated term outside of the one. I understand that there are going to be times in which this court would make exceptions, such as coming back for funerals or weddings. I understand this court traditionally does not do banishment outside of accepted negotiated terms. So to the extent this court is setting exceptions, I would defer to this court.
Your Honor, I anticipate that at some point in the future, there'll be a need to return back to Atlanta. I'm not trying to violate any agreements that I have with the state. The way I thought, quite honestly, the way I envisioned this happening was if there was a specific need, Mr. Jackson would reach out to me, and then I would reach out to Mr. Sperry. I know that creates more work for all of us, but I thought that that would probably be the best workaround at this time, and quite frankly, in the future, if things are going well on probation, then maybe we can revisit some of these conditions.
All right. Yes, but you have to tell us who you are for the record.
I'm Ms. Jones, Officer Jones with Probation DCS. Due to the fact that where he's going, if they do not accept his case, we will have to come back in front of the judge to modify the seat. I don't know that right now, and I won't know that until 7 days from today. I have spoken with my AC, so I am trying to get the situation expedited, but he won't go to see probation until Thursday.
All right, thank you. So essentially what she's saying is until the state that you are moving to accepts your probation, you will be here in Atlanta, and everybody knows that, somewhere in the metropolitan Atlanta area. Okay? All right, as to indictment 23 SC 188183, indictment 22 SC 181814, indictment 22 SC 185532. The court is going to find that the defendant has entered a pleas that were willingly, knowingly, freely, and voluntarily given, and that there is a factual basis for each plea, be it no contest or an Alfred plea or just a regular guilty plea. All right, so we're going to start with (22 SC 185532). The negotiated and recommended sentence is on count 1. The defendant is to be sentenced to 10 years to serve 3 commuted to time served. Count 2, 5 years probated to serve consecutive to count 1. Count 3, 5 years probation to run concurrent to count 1. 12 months on count 4 commuted to time served. Count indictment 22 SC 181814. Count 3, 10 to serve 3 commuted to time served. Count 2, 5 years probation concurrent to count 3. Count 1, 3 years to serve commuted to time serve. Indictment 23 SC 188183. On all 8 counts, 5 years to serve, 2 commuted to time served, balance on probation, to run concurrent with 22 SC 185532, count 1. And also in 22 SC 181814, the sentences are to run concurrent to count 1 in 22 SC 185532. During the time of your probation, you are to maintain gainful employment. You are to have no contact with any co-defendant in 22 SC 183572. I don't want to assume, is he not related to any of those co-defendants?
Sure.
All right, okay. So the people who used to be your friends or the ones they say you used to be associated with, you can't have any contact with them. That means you don't respond to emails, texts, smoke signals, shout outs, Instagram, whatever.
Not the
They're no
smoke
longer
signals.
people that you can have any contact with. Because if you have contact with them,
Carrier
you run the
pigeon.
risk of being violated on your probation and you end up in the Georgia prison system. And from my understanding, that's not the place you want to be. I understand that you were assaulted while you were, and unfortunately, that's no place anybody wants to be either. So the best lesson for everyone here is to stay out of the criminal justice system. At one point, when I was a judge on the Fulton County Juvenile Court bench, 88% of the people in the Georgia prison system did not have a high school diploma. So what that tells you is the best way to stay out of prison is to get a high school diploma. So you indicated you dropped out at 9th grade. You need to go back and get a GED so you can move forward in life. If someone wants to give you an opportunity, you can step up and take it because you can check the box that I have a GED or a high school diploma. It is basically a weeding out process and basically indicates to an employer that you know how to show up and do assignments in a timely manner. That's all they're looking for. You will show up, do the assignment in a timely manner, and not cause any problems. Because you've shown you can do that because you matriculated through high school. So they just want to know you're not going to be a problem, and they don't have to worry about you. And more importantly, the court didn't want to have to look back and say, I just should have sent you to jail, as opposed to going along with this negotiated plea. You're getting a second opportunity. I suggest you take full advantage of it. You're 32 years old. I can say to you, based on what I've seen, the next time you get a felony conviction, you're going to be looking at a lot of years. And nobody's going to say yes to probation under any circumstances. So the banishment will be for 5 years because they didn't negotiate a term. So that's for 5 years, and you can come back for special occasions, and the state and your attorney can work out what those occasions are. But you cannot come back unless you have been approved to do so and notice has been given to the state and they've signed off on it. You are to not to have any firearm in your possession because you're a convicted felon. And you're not to engage in any street game, criminal street game activity. I assume that you know all of the co-defendants in 22 SC 183572, so you know the people that you're not to have any contact with. I always make this an issue with the state because I don't want to assume that the defendant knows these individuals.
He does not know all the individuals, but he knows who they are from going through the case.
So I would suggest that the state provides him a list of all the individuals, their known names and their street names, and any other AKAs they have out there. So there's no misunderstanding, okay? And Your family members need to know that although you can have communication with them, they should not be carrying messages from any of these people that you're not to have any activity with. So, did I miss anything?
Your Honor, just one thing, if we could put on the sentencing sheet, that all these sentences are to run concurrent with, the sentence that Mr. Jackson has from 22 SC 183572.
Any objection from the state?
That's for the one
Okay,
guilty.
so all the sentences from 22 SC 181814, 22 SC 185532, 23 SC 188183 are to run concurrent with 22 SC 183572. At this time, does probation need to come on record and say anything? All right. She can't hear you.
I'm sorry. Unless you want me to tell you or the court what I'm going to tell Mr. Jackson, I can talk to him.
Yes, just put it all on the record about reporting.
Okay, so he will report on December 19th to 276 Memorial Drive, Atlanta, Georgia, 30303 at 8 a.m.
So, don't be late, don't miss that appointment, because they will come back to court and ask me to issue a warrant for you failing to appear. Do you understand?
Yes, ma'am.
All right, so at this time, is there anything else from either party?
Judge, just Mr. Sharp recommended, I have no intention of leaving my office anytime soon, at least voluntarily, so Mr. Sharp and I have built up a point of trust and communication over the years. I have no problem with Mr. Sharp reaching out to me if there's any exceptions that are necessary. That's great.
And also for the record, I will waive fines and fees for these 3 cases since he's already on probation in another case.
Thank you, Your Honor.
All right, if there's nothing further, then all parties are excused.
Thank you, Your Honor.
All right, so let's watch the camera, and then we'll go watch the Miles Farley plea colloquy.
Your Honor, that concludes the business after probation is done for the United States.
Yes.
Good to see you tomorrow.
All right.
The little shoulder.
On the final plea calendar.
Hold on.
Excuse me, position 1 on the final plea calendar.
All right. Position number 1, indictment 23 SC 186907. Marquisha Knox.
All right, so there you go. We will switch back over and continue this plea colloquy for Miles Farley. Now, guys, just as a underscore there, I know it's like, well, Shannon Stillwell, Shannon Jackson was acquitted of everything except that one gun possession charge in the YSL trial. The probation he's being sentenced to today for these cases, Max made it clear, got it on the record, that this probation sentenced today can be served concurrently with the probation that Whitaker said, all right, I'm gonna, let you serve it down. I'm gonna probate the minimum sentencing because you're a recidivist, so he can run those concurrently. But some of the stuff he was facing today are from incidents separate from the YSL trial. So it doesn't simply boil down to, but he was acquitted in the YSL trial. Why is he taking a plea? It's some different charges here. And again, going back to anyone that joined late for Deamonte Kendrick, Judge McBurney is open to granting a bond for Deamonte Kendrick. However, there's an outstanding out-of-state warrant. It seems to me to be a failure to report. And it's kind of funny, we have Judge Belinda Edwards here say, Mr. Jackson, your probation officer here said, hey, you're going to have a meeting. Make sure you show up for that on time, because if you're late, she's going to tell me and I will issue a warrant for failure to report. So very serious thing. Seems like no big deal being late for something, but that's not the case when you're dealing with probation. A whole warrant could be out for you. But if Judge McBurney looks into that, it seems to me, my guess is that if it's a failure to report for Deamonte Kendrick, but Deamonte Kendrick was in custody, that's something that'll get cleared away. And, you know, Kayla Bumpus, and I forget the prosecutor's name. But they'll be able to get together with Judge McBurney, make sure the special conditions are agreed upon, and get that bond issued for Deamonte Kendrick. So I still think there's a chance for Deamonte Kendrick to be home before Christmas. Just take some time to sort out some paperwork. As far as this, I know we've talked about it in the chat already. There was an Alford plea for count 1 for Miles Farley. Everything else was null prost. So we're going to watch this to see how it's presented. Thank you so much for everyone that's been supporting today. I'm sorry to get to these things late. Tat Clouds is out here sniping with a sprinkled gifted membership. Thank you so much. Amber Dawn became a member. I think, did you guys come in here and you're like, oh, I'm not green anymore? Thanks for becoming green again. KL's been here for 3 months. Thank you, KL. Ms. Kim says, good morning, all. Peace and blessings to all. Yes, yes. A very productive morning, too. Like 3 hearings happening at one time. Renee Stevenson says, yeah, and this is interesting, too. They usually wake Yak up 8 hours early, and today they're running late with him. Yeah, Judge McBurney said that there was, like, chaos down on floor 1. You know, obviously the ground level where everybody's arriving. Judge McBurney referenced some chaos with everybody getting into the courtroom today. So, of course, though, right, Renee? Thank you for the 5. SS3 Pisces, shout out, I'm an Aries, so you're like my neighbor, my zodiac neighbor. Thanks for becoming a member. Jennifer Devine says, thanks for channel juggling us. It's been a bit of a task. I hope everyone's okay with the order that we've jumped around in. And shout out to the chat. I think it was #FreeThugga in the chat that's like, now we've got to watch Mr. Williams' trial. When is his trial? That's we watched his bond hearing while we waited for any news or motion with this YSL hearing or for Yak or for Stillwell. So now we're just invested in new defendants. Thank you again, Jennifer. STS, great to see you. Gifting a membership. Thank you so much. Renee says, the chat is on fire. My cheeks, and it hurts laughing so hard. Miss this chat. I'm telling you, it's weird to not have it. And guys, on Thursday, there's a compilation video of some of our Michael Sprinkle moments, a good chat memory. It'll be released publicly, so make sure you check that out for some good chat memories. Thank you, Renee. Heart of Inspiration says, if they don't let this man out, they are giving him a potential death sentence. This is ridiculous. Missed y'all. So this was talking about the man, Mr. Williams, right? It seems like an interesting case. I may have not been aware of who was coming into the house and shot at somebody or got in a fight, but it was initially an assault charge, but the victim is now deceased. So the prosecutors upgraded that to a murder charge. So a lot of interesting things going on there with that, the elderly man. And of course, because of his age and it seems like other known health conditions, there's an additional issue for bond, which Judge McBurney said he's taking very seriously. And then you have the added layer of the conditions at the Rice Street jail facility. So a lot of layers there. And this is what bond hearings typically deal with. You know, you hear a lot about the Ayala factors because of the case that Georgia relies on, but really that's to meet different prongs, right? Are you a risk to the community? Are you a flight risk? All these different factors. Why should we be able to make this argument that you should be held in custody and the judge should allow pretrial detention, right? As the defense attorneys would argue, not a flight risk, ties to the community, there's health concerns, you'd be putting him at risk. In other words, county, you could become liable for something that could happen to him if you detain him while he's in custody, right? So it's not just for the good nature of making sure this person's health is okay, but it's also, I think, between the lines, a bit of a consideration. Well, how much of a liability is it on the state to house someone with health risks in a facility, keep them in custody? So all those things argued back and forth. And again, with short, Yak, Judge McBurney seems ready to grant a bond for Yak as soon as he gets more information on an out-of-state warrant that seems to be issued, failure to report for probation. So, yeah, and then Shanita talking about the Mr. Williams, not Jeffrey Williams, but this other elderly man. This judge will not grant Mr. Williams bond. And again, if you guys wanted to check out the end of that, this was the link to Judge McBurney's feed today, because we did switch over to watch the other YSL hearings when there was motion. But that link is there if you want to watch it. And Judge McBurney keeps his feeds up, so that'll stay there. Kat Fink, thanks for becoming green again. Good to see you. Survivor Speaks out here gifting 5 memberships. Big thank you. Put an SS in the chat. Thank you so much, Survivor. Law Nerd Amber becoming green again. Thanks, Law Nerd Amber. Touche says, the state says, quote, danger to community, so send them to Rice Street where they will be in danger themselves, convicted or not. And not for nothing, but right, a danger to other inmates. Inmates could be a danger to you. It's like, when you have someone that seems to have more charges from when they're in custody than outside, it's an interesting argument to hear that this person is dangerous, but the things you're relying on to say that are relating to things that are happening while in custody. And Kayla did a good job. She went down to Rice Street, the facility, especially after the December 1st incident. I think we had an acknowledgement from the district attorney that certain charges were worked out, kept off the table, right? No longer going forward. State's not going to move forward with them and prosecute them based on what was worked out. So again, a lot of the stuff that you see when it comes to bond, even pre-arraignment, you don't necessarily see on the record in front of a judge. Mahadi, good to see you, says state played dirty again, withheld info at the very last minute to keep in jail. This is in reference to that out-of-state warrant here for Deamonte Kendrick. I think the judge is open to, if that's just a failure to report because he was in custody, it's not going to get in the way of a bond, which is, I think, the right decision. Leah's dad says, when you see judges with attitudes like this, it should make you understand the YSL lawyers being thankful for Whitaker. And what's interesting about Judge McBurney is he gets an attitude, but sometimes it just seems like his attitude's like, all right, that's not even what I'm concerned about, like move it along. And then like it shifts right back in the other direction. I've watched several hearings that he's presided over, and I'll be like, oh, and then all of a sudden it like completely shifts gears a minute later. But it's true, and you have to, I think it's important to know the way your judge is, whoever you're appearing in front of. What do they care about? What do they want to see you argue? What's their pet peeve? Like if they don't like disorganization, don't go up to the lectern with a pile of scattered papers. All these little things, maybe they shouldn't matter, but if they do, you got to pay attention to them for sure. Good to see you, Leah's dad. Nana Banana says, good to see you, Kat and chat and mods. Free these men. Heck yeah. So Shannon Stillwell's coming home with, I think 12 years of probation is the math. And Deamonte Kendrick might be coming home. I think there's a good shot that he'll be home before Christmas, as long as this outstanding warrant is just a failure to report. Of course, he couldn't report if he was in custody. Good to see you, Nana Banana. Crushing hard on Max Shart. You got to see him 2 or 3 times today. Thanks for becoming a member again. And also says, I love being green. Sea Travel is out here sniping. So thank you, Sea Travel. Show Sea Travel some love in the chat. And Sea Travel, your name is making me think of Jeff from Legal Vices. So again, rest in peace to Legal Vices. If you guys haven't heard the news, he passed away on Sunday. If you didn't know Legal Vices, great streamer, friendly to everybody, extremely funny. He's a huge reason why I know so much about the law and a lot of cases. I watched Daryl Brooks through him, Kieran Reed through him, a little bit of Johnny Depp, but he was a panelist on other shows for the most part. Sarah Boone, tons of trials. So if there's trials that you wanted to go back and do a rewind on, go rewatch them. Consider rewatching them with Jeff Legal Vices. We are on a mission to get him a posthumous YouTube plaque. When you hit 100K subscribers, YouTube sends a plaque, so it would go to his family. His link has been pinned in the chat, so if you just want to hit that subscribe button, and again, his content's totally worth it. He'll keep you laughing and teach you a ton. But Sea Travel, Jeff, for Legal Vices, love to talk about maritime law, so that's why I'm thinking of him with your name. So thank you for gifting, and thanks for sparking a memory here. And let's see. Positive Q says, good morning, Cat, mods, and chat. Kayla did okay, but she should have ran a federal and state warrant search. Also, she should have had Yak's home plan, quote, spelled out. So they, for the second part, she does, but, and McBurney already predicted it, and they both said it on the record. We're not going to put this information on the record. So for that latter part, that was addressed in court. It's just, we're not going to talk about it. We have a plan, but we're not going to spell it out on this YouTube stream. So, but yeah, again, checking for that warrant. I mean, I suppose so. But it also seems like the state wasn't prepared, and that's not an unusual thing. Like, I've watched a bunch of bond hearings, and, you know, there's a decent amount where all of a sudden, like, oh, we didn't know about a warrant. Oh, we didn't know about a warrant, which I think is really crappy in general. So, because it's like, imagine thinking you're about to come home and then you find out you have an outstanding warrant and that's the only reason you cannot come home, right? That's got to be crushing. Red Bunny says, I recall when there was only 8 of us in the chat, like little baby channel. Shout out to Red Bunny. Not just an OG here, but also following this trial from all the way back, and very informative, knows a ton of the little details. So glad you're here. Curious Coco New York says, sends love to the slat chat. Miss y'all. Right? We have like a little reunion this morning. Raylan Encina says, can't even become a lawyer yet hating on Kayla. And let me say, if somebody wants to get into law, remember, you don't need to do something that puts you in the courtroom. And I think about this a lot. Do you think these things being streamed might deter people from wanting to be a trial attorney, or, you know, even things like being a prosecutor, which I think the sunlight is good, right? Obviously, sunlight, if I want to be a shady prosecutor, being on camera and having hundreds, thousands, sometimes millions of members of the public being able to see the way I act in the courtroom, I think that's a good deterrent to shady behavior. But at the same time, not everybody's comfortable being on camera, and I wonder if there's someone that would be a very good advocate that's like, I wouldn't want the Cat Nut Williams chat room criticizing me, and I'm just going to choose a different career path now. So I wonder if like the new age of like online trial streaming is impacting career decisions. But really the point here, there's a lot of fields, you know, that are legal that don't involve you being on the floor in the courtroom, and what has to be nerve-wracking, right? I would be shaky, my voice would be nervous. But yeah. And this is a good point. So Raylan also says, no, I don't think so. I think the stream trials seem to have had a positive impact on people wanting to get in the legal field. And this is, let me get a link to it, you guys. If you didn't see, the New Yorker did a piece on, with Thugger Daily. And forgot to mention it earlier, but it was super awesome. A nice little read. And Thugger Daily, it's one of those examples of, you know, I might want to do something in the legal field because of everything that, you know, I've done or seen in this trial. So if you want to read a link, here is his post, and in a reply, he has a link to the New Yorker article on him. So really interesting stuff in there. I liked it. Oh, and then get this back up. And you're right. Like, I think Taylor Umbridge, I think she was planning to get into law anyway, but very, very enthusiastic, I think, because of watching these trial streams and being able to learn more about trials in this type of setting. Taylor Umbridge is obviously very motivated for her career in law. So this is very true, Raylan. Flesh of the Gods is also out here sniping. So Flesh of the Gods said 1, 2, 3. Thank you, Flesh of the Gods. Great to see you. And it's Tuesday, right? So are you going live at 8? Let us know. Major Drama, thanks for becoming green. You look good in green. Chris G, good to see you, says free SB. Hey, Cat and chat. And yes, we will have SB free. I'm assuming, I hope we get another, that video of Brian Steele and Keith Adams and Jeffrey Williams leaving the facility. Wonder if we'll get another one of those. Let's see, Tack Clouds also, thank you again, Tack Clouds, out here gifting again. Just sniping a little bit throughout the stream. Paulette gifted 5. Shout out to Paulette in the chat. Hope you're doing well. Love the profile picture. And let's see, Touche says, can't say much for Glanville, but I think Paige and this lady truly want the best for these men. Oh boy. Speaking of bond hearings, guys, if you were looking for YSL content and you can stomach it, go back and watch the bond hearings for the YSL defendants. Steele took up a lot of time, right? You're going to hear how much the state relied on that quote that Viverito talked about and said she would still put in the affidavit the same way. That 24Ms, the diamond, the Lil Uzi Vert forehead diamond. You're going to hear the things that the state relied on to tell Judge Glanville, to which Judge Glanville agreed that Jeffrey Williams was a danger and bond should be denied. So, oh, why did my window go away? Let's get that back up. Law and crime. Get that queued back up. Amber Dawn Them Johnsons, I love this. Says, drop a home in the chat. Love that. Love the house emoji. I think there's like a few house emojis, right? There's one that like is a fixer-upper. There's this one. I think there's one with a tree. And then there's one with like 3 houses. And I only know that like from real estate marketing, doing the social posts. It like probably way overused the house emojis over here on my end. But a good use for them today here. Drop a home in the chat. Happy Annie with the positivity here says Kayla and Max did great jobs. I agree. Amber also says, oh my gosh, we're gonna do it, guys. I bet Viverito. We need one more. One more. Viverito in the bushes. She's gonna be in the bushes in Texas. Oh man. I really can't wait to see the testimony with the second YSL trial from these gang experts. Like, are they going to change their stance on anything? Are they going to concede certain points where they were dumb about, like this 24M diamond? Delicates of Life says, I don't think he should go to Texas. Relationship may not last. Now, this might be, I think this is fair, right? Things can happen and you move out of state, your family could be here, but there is an extra layer here that I think wouldn't be there in ordinary circumstances, right? You hear of someone moving long distance for a relationship, maybe mom's sad about it, family members are sad about it, friends are sad about it, who knows? But here, he's got to leave the metro Atlanta area anyway. So for what it's worth, there is an additional factor in play here where it's kind of like, he's got to go somewhere. So I think that obviously wishing everyone the best, but that's life, right? And the name Delicates of Life, probably perfect name for this type of food for thought. And then Nancy New One Too says, I'm surprised they didn't ask where Mr. Williams would go if released, as his neighbors are witnesses in the case. Nancy New One Too, this might be because we switched the feed. That might have been a question that the judge was going to ask. But this is, I think, a good question. Any conditions, neighbors are witnesses. Is there any risk? probably a good thing to hash out, but we might have just missed it because of the way we've been jumping and juggling the stream. With that being said, thank you guys for the support and the generosity today. Let's listen to this plea colloquy. Even though we know the outcome for Miles Farley, we'll still listen to how it's presented. And I think we're kind of queued up.
Yeah, any of the defendants?
Yes, Your Honor, Anastasia Smith and Mr. Miles Farley, we have a.
All right, why don't y'all come on up to the podium, please? All right, Mr. Body, whenever you're ready. And everybody, I'm just going to give a reminder to just use the mics. They're in front of you and they're mobile, so you can move them up close so that everybody can hear.
This is indictment number 22 SC 183572, State of Georgia versus Mr. Miles Farley. Mr. Farley, please raise your right hand. You solemnly swear and affirm that the testimony about giving the matter pending before this court will be the truth, the whole truth, and nothing but the truth, sir? Yes, sir. And put your hand up. Could you please state a true, correct, and legal name for the record? I'll let you sign before asking all questions. Two things once.
And Mr. Body, maybe reposition the mic while he's doing that.
Yes, sir. Mr. Farley, could you state your true, correct, and legal name for the record? Farley. And Mr. Farley, are you at this time taking under the influence of any alcohol, drugs, or medicine? No. Is there any medication that you take daily or regularly that you have not taken today that would affect your ability to understand why you're here? No. And how old are you, sir? And how far have you gone in school? I got a bachelor's degree. And are you able to?
also speak into the mic, please?
26 and got a bachelor's degree. And so are you able to read, write, and understand the English language? Yes. And do you understand you are charged in indictment number 22 SC 183572 with count 1, conspiracy to violate RICO, count 49, which is related to the homicide of Mr. Drinks, counts 50 and 51, which are both participation in criminal street gang activity, and then count 54, which is a possession of a firearm in the commission of felony. You understand you're currently charged or indicted with those counts? Yes. And do you understand that you have the right to plead either not guilty, guilty or not guilty to these charges, and if you pled not guilty, remain silent, you may receive a jury trial? Yes. And has your attorney, Mr. Menendez, gone over the rights that you're waiving by taking a guilty plea here today, sir? Yes. And are you satisfied with the services that your attorney has provided? Yes. And do you need any additional time to talk to your counsel about any of the facts and circumstances regarding the charges and the circumstances of this case? No. And Mr. Menendez, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this hearing or plea?
Yes, so waived.
And Mr. Farley, has your attorney spoken to you about the minimum and maximum penalty for the counts that you're pleading guilty to? Yes. And he advised that for count 1, RICO, the minimum is 5 years, the maximum is 20 years? Yes. And do you have any questions as it relates to that count, the single count that you'll be pleading guilty to? No. And so do you understand that this is a negotiated plea of guilty, which means the state and your counsel will offer a joint recommendation to the court as to the sentencing recommended for the count that you're pleading guilty to, but the court does not have to follow that recommendation, and she can sentence you as she sees fit up to the maximum for the charge. Please. Do you have any questions about that? No.
Is he just pleading to count 1 and y'all are null processing the rest as a part of the agreement?
That's correct, Judge.
Okay.
Now, do you understand? Mr. Farley, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts? Yes. And do you also understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anyone else? Yes. Do you understand that you waive any and all defenses by entering a plea of guilty here today, sir? Yes. Do you also understand that by pleading guilty, you're giving up or waiving the following rights: the right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you're unable to afford an attorney for the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges proved against you beyond a reasonable doubt at the state of Georgia, and the right to appeal if convicted of these charges after trial. You understand by taking a guilty plea here today that you're waiving or giving up all of those rights? Yes. And Mr. Farley, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today? No. And are you pleading guilty, sir, because you have decided in speaking with your counsel, Mr. Menendez, that you believe that is in your best interest to do so? Yes. And are you aware that even if you're not admitting guilt, as you're pleading under North Carolina versus Alford, if the court accepts that this plea of guilty places you in the same position as if you were convicted after a jury trial? Yes. Okay. And how do you plead to count one, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act in indictment number 22 SC 183572? Guilty on the Alford. And Mr. Farley, is this Alford a guilty plea freely and voluntarily given with full knowledge of the charge that you're pleading guilty to? Yes. Do you understand that you may have a limited right to appeal this guilty plea conviction? Yes. Do you also understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea? Yes.
Challenging anything about the constitutionality of the guilty plea, understand?
Yes, Your Honor.
Well, I want to make sure he.
Yes, ma'am.
All right.
Do you also understand, sir, that you have 30 days from today to file a direct appeal from this guilty plea, and until the end of this term of court to file a motion seeking to withdraw this guilty plea, which doesn't mean that the court necessarily would grant it or not. It's just that's the time constraints that you have to file under those areas of the law. Yes. Okay. Do you have any questions about that? No. Okay.
All right, and your attorney, Mr. Menendez, will represent you until 30 days from now or the last day of this term of court, whichever is later, and he would be the one to file any of those things on your behalf unless he is allowed to withdraw before that time. Understand?
Yes, ma'am. Hang on, just for the record's clear, I just provided to Ms. Percival the indictment, which was signed by all parties as it relates to the defendant's guilty plea to count one, conspiracy to commit RICO. Your Honor, as the case proceeded to trial, the state would have shown beyond a reasonable doubt that between January 24th of 2013 and May 8th of 2022, this defendant, Mr. Farley, in conjunction with his fellow co-defendants, co-conspirators, known YSL associates, did unlawfully conspire to conduct and participate directly and indirectly in the enterprise that YSL. In doing so, they did it through a pattern of racketeering activity, conducting and participating in YSL with the same common objectives, which were to preserve, protect, and enhance the reputation of the enterprise, that being YSL, doing so by protecting the power and territory of known YSL stronghold.
Oh, guys, sorry. That's me causing the buffer. But I think dropping a link in the chat to the press conference that Touche, thank you for relaying. That's why it's buffering. But Kayla just said that probation told the judge about Yak's warrant today. None of them knew. And that's why the first person I think mentioned it was the prosecutor, just saying, and he said that it was like, we just found out. So this I'm linking if you guys want to check that out.
Acts of violence, also through other means such as social media, posting messages, images, things of that nature. That's what the state would have shown as it relates to Mr. Farley and his involvement as it relates to the enterprise YSL and his association, Your Honor.
All right, I assume at least some of the evidence would have been the same as or similar to what was presented at the trial of some of the co-defendants that just was completed a couple of weeks ago.
Yes, Your Honor, very much.
All right, so I'll take that into consideration with regard to the factual basis as well. All right, anything else from the state?
Nothing further. The recommendation as it relates to, or the joint recommendation that the parties would make into the court, it's my understanding that the defendant obviously would like to tender his plea under North Carolina versus Alford, and I neglected to ask Mr. Farley, but it's also my understanding he qualifies for the first offender treatment, and he is asking that the court treat him as a first offender, which the state has no objection to either, and the recommendation would be 5 years to be served on probation.
All right, Mr. Farley, has your attorney discussed with you the First Offender Act and what all that means?
Yes, ma'am.
All right, and have you all discussed the potential upsides and downsides of that?
Yes, ma'am.
You understand that if you successfully complete, if I sentence you in accord with what has been negotiated, if you successfully complete the probationary time without having any violations of your probation, that at the end of that, you would not be a convicted felon, understand? All right, you understand as well that if you do not successfully complete that probationary period and your probation is revoked, that not only could you be revoked for that 5 years, but the court could actually adjudicate you guilty, find you guilty, not under first offender, but just straight guilty, and impose up to 20 years imprisonment for the count to which you are pleading guilty under Alfred. Do you understand that?
Yes, ma'am.
All right. Mr. Menendez, is there anything else that the defense would like to place on the record?
Yes, sir. I just want to add a little bit of nuance to the plea in case the court's not as familiar, because a lot of it was on the front end. Mr. Farley is an HBCU graduate with no criminal record, and it's actually his marketing and his genius work as a businessman that even brought him into all of this, which is why we're asking the court to sentence us under Alfred. In 2019, him and a friend created a clothing item, a hat, that was like a satirical play on the Trump hat where it said "Make America Slime Again" instead of "Make America Great Again." And Your Honor, the clothing brand never said anything about YSL. It was just using this youth term slime, which I'm sure by now the court knows can have many different meanings in many different contexts. Mr. Farley is born and raised in the Cleveland Avenue area, and he does exemplify a lot of the great qualities of the people of that area, his creativity, intelligence, tenacity, his bravery in taking things as far, Your Honor, putting his foot down when he was faced with this, government abuse. But what he did next, Your Honor, is he went to Miles College, and then despite having a vast network of opportunity from his bachelor's degree in business, he returned home because he is a family person. His dad is here in the yellow hoodie in the back. He's also an entrepreneur. That's where Miles gets a lot of that from. And so, Your Honor, when Mr. Farley made this clothing brand, he built off of the hat. In 2020, he made an LLC for Make America Slime Again, and he's actually employed by a record label to be a handler for a musical artist. And then he used those associations and that presence to promote his brand and to have his clothing be as visible as possible. He started making custom pieces for different artists and different people. And Your Honor, if you remember from the evidence that was presented, Mr. Farley's always wearing his own clothing, and he's only ever promoted his clothing for the purpose of himself and his business and his family. And so that's why, Your Honor, I think the most sincere and appropriate way to resolve this case is under Alfred. The state, in that respect, did the right thing with its discretion, dropping the murder case. Mr. Farley had nothing to do with the death of Mr. Drinks. And so, Judge, he's been on house arrest. He's been totally compliant. He's not a gang member. He's never committed a crime in his entire life. But he is wearing an ankle monitor. He is confined to his home. It's better than jail, but I think we all know after COVID that that's not necessarily ideal. And he just doesn't want to go to trial. And that's why I think Alfred is a textbook case for this type of situation. And so if the court has any questions, we just ask this honorable court to accept the plea as negotiated.
Okay, well, I mean, it would be determined by a jury at trial whether his involvement in the case is only because of his marketing and business acumen or something further than that, something criminal. But in tendering a guilty plea under Alfred, Mr. Farley, you are admitting that while you do not believe you have committed the crime of conspiracy to violate the RICO Act, you are acknowledging that there is sufficient evidence that the state could present to a jury from which a jury could conclude that you are guilty of that crime. You understand that, right?
Yes.
All right. All right, I find there to be a factual basis for this plea. I will accept it under Alfred, and I'll permit it under the First Offender Act. And I find the plea to be freely, knowingly, voluntarily, intelligently entered with an understanding of the consequences. And in accord with the negotiated recommendation, I am going to sentence you to 5 years probation. And as we discussed before, how you perform during the next 5 years of this probation is going to determine whether you finish that, a person who can say that they do not have any felony conviction, or whether you might be spending some time potentially incarcerated. So it's entirely up to you how you comport yourself and how you choose to behave going forward. What ultimately will happen at or before the end of that 5 years. Do you understand that?
Yes, ma'am.
All right. Are there any special conditions to this probation? Have y'all negotiated any?
They didn't have any special conditions, obviously, other than follow the law.
Okay. All right. Well, that is the sentence of the court. I need to ask if you have a weapons carry license. Do you have a license? Okay.
No.
All right, that's fine. And while you cannot have any firearms during the course of your probation, if you successfully complete all your probation, you'd be able to possess firearms again. All right, Mr. Farley, good luck to you. I know that you have a very successful business, and let's just make sure that that business is on the up and up and that you're following the law. All right, good luck to you. Thank you.
Thank you, Your Honor.
And is there somebody here from probation?
If you would wait, Ms. Jolly is on the way.
All right. Mr. Menadas, wait until the probation officer, Ms. Jolly, can meet with y'all and get all of that taken care of.
Yes, Your Honor.
All right. Yeah, that'll be fine. And after you meet with her, then you are excused. Thank you. All right. Are there any other guilty pleas that are going to be tendered today? All right. So what I would like to do is, and we can just start up here with Mr. Mender, and I'd like the state to put on the record what the plea offer is. And I want everybody, all of the four defendants, and Mr. McMullen, we just heard from your attorney, and he believes he will be here by 11:30. He's apparently in Gwinnett County on some other case right now, and we'll have to just sort of wait until he gets here to handle yours. But this applies to you as well, for everybody. This is the final plea date. It's your first final plea before me. I know that y'all had a final plea before Judge Dempsey previously, but I gave you all the opportunity post the verdict in the case with some of the co-defendants to negotiate if you chose to, and have a final plea date, if you will. That this will be your last opportunity to enter a negotiated plea in this case, meaning you all in the state have agreed to a recommendation, and you can be assured that if I do not accept that recommendation, that you can withdraw your plea. Now, you can obviously at any point in time enter a non-negotiated guilty plea, and that would mean that you decide to plead guilty, and the state will make a recommendation as to sentence. Your attorneys will make a recommendation as to sentence, and it will be entirely up to the court to sentence. Could be above or below what any of the recommendations are, could be exactly what one of the recommendations is, but as long as it is within what is permitted by the statutes. And then, of course, you have the right and opportunity to proceed to trial on the case as well. Does everybody understand that?
Yes, ma'am.
Okay. All right. So, Mr. Mender, you have this case pending, and you have another case pending.
We're just doing
as well.
scheduling.
And Your Honor, so we were going to respectfully request to hold our announcement and to have an opportunity to approach the court at the bench at whenever convenient before we move forward with the
All
final.
right. So I will.
That's
come back to
Nicole
y'all.
Fagan.
So, Mr. Garlington and Mr. Mondelli and Mr. Abbate, can you put the offer on the record for Mr. Garlington?
Yes, Your Honor. Your Honor, on December 9th of 2024, the offer was relayed to counsel for Mr. Garlington as it relates to the possibility of tendering a guilty plea. The recommendation from the state was for the defendant to plead to count 1, conspiracy to commit RICO, count 49, which is the murder count, but it be reduced to the lesser included offense of voluntary manslaughter, and him to plead to count 50, which is participation in criminal street gang activity, and then count 54, possession of a firearm during the commission of a felony, with a global sentence of 30 parolable time.
All right. And as a part of that plea offer, you all were going to null cross 40, 42, 43, and 51. Is that right?
That's correct, Judge.
All right. All right. And Ms. Rondelli, you discussed with your client the potential sentences that could be faced if he goes to trial and is convicted of all counts.
Yes, Judge, we've spoken extensively about potential risks of going to trial, and made the offer to Mr. Garlington on December 10th. And we've had some discussion with Mr. Abbate since then. We are not in a position to accept the offer that's placed on the record. We will be rejecting that offer. I will state that there are further discussions that are taking place. We understand the court's admonition about any resolution after this.
Yeah, and y'all can certainly present a joint recommendation. It's just not going to be negotiated per se at that point, in that you would have a right to withdraw the plea if the court didn't sentence in accord with that. But I mean, I will say, and this is certainly no guarantee, but I think across the however many years I've been on the bench now, I typically still, if there is a joint recommendation, certainly take that into account, and fairly often probably sentence in accord with that, but that is certainly not a guarantee. So, Mr. Abbate, would you be able to put on the record
Hello. Why is it doing that? I don't know if it's like still going and it's, I don't know if it's law and crime or if it's me. Because it's not doing the
I would say
circle.
another thing as well, I know that there was a not guilty or a not guilty verdict for most of the counts that faced the two defendants who proceeded all the way through to jury verdict. A trial for any of the four of you would be before a different jury. I would suspect that a lot of the evidence would be the same. The way it is presented might not be the same. I don't know, state's sort of story, theory, if you will, might or might not be the same. And the ultimate outcome might or might not be the same. And I'll tell you, and I'm sure that all of your attorneys have told y'all that acquittals with a jury are a rarity. So just keep that in mind. It does not mean that the same thing would happen to you. Y'all, you know, we've got a different prosecutor at the table who I hope would stay through the trial of the case. And it just is probably going to look a lot different. There's also a different judge at the beginning. So just keep that in mind. But I understand that for now, y'all will be rejecting that offer. All right.
That's a little interesting. It seems like she was trying not to throw too much shade, but also at the same time, that's a thin line, I think, to say that keep in mind that acquittals are rare. Because talking about Jimmy Winfrey, Pee Wee Roscoe, why did he have one of his convictions overturned? And I think there's a difference here. It's not quite as, well, you heard that somebody else was just found guilty, right? But at the same time, you're telling someone to make a decision based on a statistic about acquittals. That's a little bit, if you ask me.
So we've got Mr. Eppinger, and I know Mr. Eppinger still has a motion pending. I will tell, and Mr. Johnson, you should now have all of the transcripts from the main witnesses who testified around the two attempted murder counts at trial. And if we are not having a plea today, I'm obviously we're not going to have that hearing today, but I would be interested in going ahead and getting that scheduled. And I will say that I have heard the testimony as it was presented at the last trial, and I have seen the videos. I don't know what might be presented at the immunity motion, but I'm fairly certain that those two videos would be presented again, and I'm already familiar with that, as are y'all, having had it in discovery for a long time now. But we're going to go ahead with the final plea now. So even though that motion is still pending, any plea that you might be interested in tendering at some further point in the case, if you ever decide to do that, would be non-negotiated. Just
Understood,
Mr. Eppinger, you understand that as well? Okay. All right. So, Mr. Abbate, can you put on the record what the offer tendered to Mr. Eppinger was, please?
Yes, Your Honor. The state offer as it relates to Mr. Eppinger was a global sentence of life imprisonment as it relates to the armed robbery and everything else to run concurrent on this indictment. That sentence to run consecutive to the time he's currently serving in DOC custody, Your Honor.
All right.
Mr. Eppinger is facing a minimum of a life sentence and a maximum of 2 consecutive life sentences plus 145 years, Your Honor.
And I don't, this is just my quick count, but Mr. Eppinger is facing approximately 15 different felony charges on this indictment. Is that right?
That is correct, Your Honor.
All right. And if he were to proceed to trial and be convicted of all counts, in addition to everything running consecutively so that it would be, I'm sorry, I think you said 2 life sentences plus 100 and how many?
165 years.
165 years. That time could also be run consecutively to the time that Mr. Eppinger is already serving on whatever he's convicted of already. So have you explained that, Mr. Johnson, to Mr. Eppinger?
Yes, Your Honor.
You understand that, Mr. Eppinger? Okay. All right. And was there something else you wanted to say?
No, just based on circumstances, I came to the podium.
Okay.
Announcement. But
Given the state's offer, Your Honor, at this time, we would reject that offer based on our view and our view of the evidence in this particular case.
All right.
So, yes, we would reject that matter and like to proceed to trial.
All right, and once I get through everybody, or maybe everybody we can get through right now, I'll talk about trial dates. And I'll talk with y'all first about in the immunity hearing date as well. All right, thank you.
Your Honor, I believe that motion can be held as close to trial as possible.
Well, I mean, it could be, but I'm not interested in doing that. I'm interested in getting that taken care of as soon as possible.
Thank you, Your Honor.
All right, not December though, not that soon. Okay, so have we covered everybody other than Mr. Mender at this point? Yes. All right, so let's talk about then the number of witnesses. I would think maybe about 4 or so for the immunity motion?
State would have no witnesses.
None? Okay.
Your Honor, as far as witnesses in the case, I believe the only witness that may be necessary is the
You can pick it up. It's not.
Is the complaining officer, Your Honor. That would probably be
Okay, well, there are 2 officers who got shot.
Well, actually, there's only one who got shot.
Well, one who got shot out and one who got shot. You're right. I stand corrected on that.
So
your motion is just with regard to the one who got shot?
No, Your Honor.
I didn't think so.
No, it is related to both.
Guys, this is not immunity as a deal. This is immunity from prosecution motion. So for Eppinger, there's an outstanding motion that nobody's had a hearing for, where the argument is that Eppinger should be immune from prosecution in relation to the shooting of Officer Rogers and maybe one of his partners, because it could have been in self-defense, or it could have been in defense of habitation, or in defense of others. So they haven't actually had a hearing on this motion that was filed months and months ago.
But the other witness is not necessarily important for the
Okay.
motion.
All right. So that should be able to be taken care of in what, 4 hours at most?
I would imagine no more than an hour.
I mean, I think 2, but half a day at most, right?
I don't even think it'll take that long, Your Honor.
Okay. All right. So let's go ahead and get that scheduled then.
I guess I would have my inquiry with the court and counsel would be, it's the burden of the defendant to show that he's acting in self-defense. Typically, you don't call the complaining witness or the victim to establish your intent, how you're acting in self-defense.
I mean, if he wants, whomever he wants to call, he can call. And I get that. So do you think you'd be
Want to call
calling the
Rogers?
client? Because it sounds like the state does not intend to call any witnesses.
Understood, Your Honor. It may be a situation where I may call my client after discussion with him, and it may be a situation where we may just, the calling of the witnesses is just necessary for the introduction of the video, and we can make arguments based on that.
Okay. So let's look at.
They want to show that video of Officer Rogers not introducing himself.
If it's just the video, state would stipulate to the video coming in, Your Honor, making a.
Okay. All right. Did you? I don't know if you heard that, Mr. Johnson. If it's just the video, then the state would stipulate to it coming in. I think there were. All right. Let's do 10 a.m. January 13th.
Your Honor, I did file a response.
Yes, I saw that. Thank you. I appreciate that. All right. And then with regard to the trial, we're at this point looking at potentially 4 defendants for this trial. Does the state have, I mean, the last time I asked, we still were facing 11 defendants. So do y'all have a revised estimate as to the time it would take to present the state's case?
I think it would be less than 90 days, but in abundance of caution, instead of overpromising, I would say at the most 90 days.
All right. And when you say 90 days, you mean from the time we start presenting evidence till the time the state rests would be 3 months' time, not 90 days of trial time, right? Okay, just making sure. All right.
Big
and then
distinction.
obviously the defense would evaluate the state's case before determining whether they wish to present evidence. But any general idea what anybody thinks might get added on?
On behalf of Mr. Mender, if Mr. Mender was to go to trial, we would want 1 witness, and it would be who we would need a production.
Okay. Okay. Mr. Johnson, and I'm not holding you to it now, I'm just trying to get kind of an estimate.
Your Honor, based on our view of the evidence.
I need you to pick up that mic, I can't hear you.
Based on our view of the evidence, Your Honor, I do not believe that we'll have any witnesses for Mr. Evans.
Okay, and obviously that's assuming that it proceeds past the immunity motion. All right, and then I'll hear from Mr. Dark, but okay, so we're talking about probably still roughly 3 months. So 3 months is probably an overestimate on the state's case. Okay, so in terms of picking the jury, do y'all want to do jury questionnaires, or do you just want to have people in and do it all live? So, I mean, if this were a typical case, I wouldn't call more than 72, but.
My experience is that they are more comfortable being honest and letting their thoughts come out in the questionnaire.
Okay, excuse me.
So they're just figuring out the process for voir dire.
All right, so I know that at least as sort of a pilot project, Jury Services here in Fulton has some, I don't know, tablet type things that jurors can answer the questionnaire electronically, but I think they basically like come in, but just sit and answer the questionnaire, and then we have them back another day for follow-up. So we could do something like that if everybody's amenable to that. Okay, and have y'all thought at all, I guess did y'all already go through at least part of jury selection in this?
We did.
Prior iteration? Some of you did and some of you didn't, right? All right, so, I mean, I would need to know what type questions y'all want. So can y'all by, let's say, January 20th, have the potential questions that you all want asked?
And I think the previous questionnaire was sufficient, but it was redundant.
Well, we don't want redundancy. I'm not a fan. Well, redundancy every once in a while is a good idea, but I want to be efficient. Okay, so I'll pull and look at the last questionnaire, and if, y'all do the same, and if there are ones that you think we can strike, and any that you think we need to add, if y'all can just let me know that, and maybe we'll have, let's look and see what the 20th looks like. Maybe we can have, the 20th is the MLK holiday, so let's not do it that day. Let's do the 17th, which is the Friday before. Why don't we plan to just have like a status on, let's say 10 a.m. on the 17th of January, where we can, so if y'all would submit whatever kind of additions, deletions you would like to the jury questionnaire by close of business on the 16th. We'll meet on the 17th for a status. And
the judge said, everyone in this courtroom on 17th.
Everyone who is still wanting to proceed to trial at that point in time. And in addition, Mr. Dark. And then I know the state had proposed, did y'all say February 24th as the beginning of trial?
Yes.
I had been thinking, I mean, is that a trial day for us? We can.
Make it one, but
I'll speak in Mr. Dark's place. He had sent an email after I filed my motion. Apparently he may have leave filed on that day. I can't.
Let's find out whether he does. If it's not filed in this case, it doesn't really matter.
Anybody else have any kind of an already filed conflict with beginning trial that day? Okay.
I have these, but.
These had already filed?
They are filed.
Okay.
But things can be rescheduled, so that's not an issue.
All right.
Does the court expect to have jury filling out questionnaires prior to the day that we're starting?
I mean.
Because there's a couple things that can happen.
Yeah.
So one is the questionnaire, and with Mr. Abbate at the table, it might be more then we can at least dwindle down and not have to waste time on whether or not.
People who are clearly going to be stricken for cause.
Right. And I think those things, like, they can get the questionnaires done, we can.
Yeah, I mean, I definitely think we need to get the questionnaires back before we have them back for the, you know, day of actual questioning, or days, I don't know, of actual questioning. So.
Reading of the indictment is a day of us sitting there, or was a day, multiple days.
Let's see what we can.
I mean, it may be that the state's not intending to go forward with all, however many overt acts it was before, 213 or something. They may winnow down the indictment. Could you have that done before the 16th as well, or by close of business on the 16th? Okay. And there's no, well, I was going to say there's no reason to read the counts, substantive counts that are against defendants other than these four or whomever it ends up being. But they may be overt acts anyway, but we wouldn't need to read the counts, even if they were included as overt acts. So, you know, it would be a redacted indictment that we read. But yeah, we'll talk in more detail on the on the 17th about that, you know, what date we're going to have jurors in, how many jurors think we need to call, things like that. Okay. And then I know there are no, other than the immunity motion, no outstanding motions, but are there going to be motions in limine, evidentiary kind of things that have not already been resolved? I need y'all to think about that and get all of those filed by January 16th as well. Okay. Actually, if y'all could get those filed by the 15th, that would be good, and then I could be taking the 16th to start looking at them, and maybe we can talk through some of them on the 17th.
Can we have a deadline for a discovery Dropbox link?
I would sincerely hope that all the discovery has been shared by now.
I know they're working on consolidating some of the new stuff that came out as it relates to during the trial.
Okay.
But that shouldn't take very long. I know Mr. Dark has received the majority of, it's just taken a minute, over 8 terabytes file from Mr. Dark, so that's been the focus. But I will make sure.
Yeah, so if you, the state, could put together your narrowed, cold, focused discovery.
Yes.
Can you get that? When do you think you could get that to all the defendants? Because even if they have everything, they'd probably rather have the smaller universe of things.
The first week of January, is that sure. Right?
Yeah, that works. All right, so that would be, find my calendar again. January 3rd. By close of business, January 3rd. All right, anything else we need to think about right now? All right, everybody else, I'm going to go ahead and release Mr. Abbate. Obviously, you'll need to stick around and we
release him from his
11:30
abandoned
arrival
ship
time for Mr. Dark. So we'll hold on to Mr. McMullen as well, and then once we have Mr. Dark, we'll reconvene for his final plea and to discuss with him the deadlines we've set. Was there something else, Ms. Fagan? Oh, sure, yes, I'm sorry, you did mention that.
I don't know if they come back. I don't think they do. Yeah, they don't come back after this, so they end up staying off the record. I do want to watch, guys, we've got two things. We're going to look at the state's response to Eppinger's immunity motion. It's 8 pages, so it's not that long. We'll look at that. And I also want to look at the press conference from Kayla Bumpus and Max Shart. I had it open and I closed it, so let me pull that back up. I think it's still at the timestamp. Was this where it was? All right, it's coming up. Also, thank you so much in the chat here. Happy Annie said, look, we're going to turn somebody green. Big thank you. Kay Grammer said, me too, I want to turn somebody green, which is super awesome. There is a new members only video, you guys. I don't really do members only because I want you guys to see stuff. It is going to publish publicly on the 19th. It's a Michael Sprinkle song and a memory of the chat. But if you just got a membership, you can go and check that out today. Get a sneak peek. Speaking of music, because there is a Michael Sprinkle song in that video. Speaking of music, we've got Classy Beats in the building. I saw the chat already giving a big warm welcome. So thank you for, chat. You're always so kind and welcoming to everybody. So thank you. I especially appreciate the warm welcome to Classy Beats and Amy E when they arrive in the chat. And Classy, thank you so much for gifting 10. Now, if you guys, I know a lot of you come in here and you miss getting together in the morning. We're not doing these daily YSL streams while there's no trial. But Classy Beats does a morning show every morning talking about subjects just like this. So make sure if you aren't already, you go over there and hit that subscribe button and hit that bell because you want to know when he goes live. So definitely do that. Good to see you this morning / afternoon, Classy Beats. And Amber Dawn Them Johnson says, DA literally just turned him, this is about Miles Farley, into a convicted felon right before our eyes. He has to complete first offender in good standing. Right, so he's got a 5-year program, Miles Farley. And if he gets through it, no, he won't have that felony status on his record anymore. But he's got to get through that 5 years, which I have faith he can do it, right? I'm going to be positive. But you also have people in the bushes looking for a reason to mess it up, just like Viverito. So it's not necessarily, in my opinion, just as simple as stay out of trouble when you have somebody that might be trying to insinuate that a piece of clothing you put together equals trouble, right? So it's just not a simple, he'll be fine. I hope he's fine. And I don't think he's going to commit any crimes. I think it's crazy that he was attached to this case in this way and that he had to take even an Alford plea on the count 1 for RICO. Everything else is null prost. But he was facing RICO and charges relating to Chamel drinks. And he was supposed to be a passenger in the car that Quamarvius Nichols was in. So it's kind of like you let Quamarvius Nichols take a plea. And we know that there was an acquittal for at least the charges relating to Chamel drinks for Shannon Stillwell. And you've got Miles Farley, who your theory is that he was a passenger, and you're still going to make sure you get this RICO on him. It just kind of shows you again, for anyone that says all they care about is this RICO charge, it goes to that. To me, it goes to that. So, and then let's see. STS back again. Let's show STS some love in the chat. Thank you so much, STS. I've been missing my daily STS here. Also, I saw Jim R in the chat, and I think Jason was talking about it earlier. I think we can say it now. So, Jason Hodges got word, and I'm not sure if this is coming from the Fit Lawyer ATL or if it's been going around on other channels. I'm behind on catching up on stuff, but the Fit Lawyer ATL is working to get some assistance to Munktunk to help him with that probation revocation. So keep that in mind. There's been a lot going on behind the scenes. STS and Jim R both did a lot to do a deep dive into the pleas that we heard about in the YSL trial. Jim R especially has gone back and dug through the records and the charges and different things in Munktunk's record. And the Fit Lawyer ATL, thank you, Jason Hodges, for bringing that forward and saying it publicly. But the Fit Lawyer ATL, she is an Atlanta attorney. She's helping. So big news. Make sure when you see the Fit Lawyer ATL, I don't know if she's still in here, show her some love. Show some love to STS. Show some love to Jim R. They've all been, everybody's saying free Munktunk, but they've been really making sure that nobody forgets. So, yeah, so this was, yes. So, shout out to Jim R. Shout out to Jim R. Okay, thank you, Jason. I figured, Jason says I got it from the Fit Lawyer ATL. There you go. So it's official from the word of mouth from the Fit Lawyer ATL. Thank you, Jason, for relaying that earlier in the chat and confirming that here. But that's huge, guys. That's huge. So yeah, she officially announced it on her live. And I want to give a big shout out to the lead attorney because I think he kind of knew this was in motion, right? So I'm very excited to see the Fit Lawyer ATL's channel growth, but I also think some of the support for her was beyond just helping her channel grow. I think it was we know that there's some motion here. I'm really excited to see that. I see that court is back. So we'll do that. We'll do that. Because you guys are yelling at me in the chat, my bad. All right, I'm at the point where the camera's moving. I'll put it on 1.25 until we're caught up. Share this screen. We'll also get to that press conference, you guys. Here we go. We're here. We're here.
All right, I'm going to come up to one of these cluster tables.
Okay. Oh, you know what? It's because they're not using the real. Like they have like a laptop streaming this today because something with the Rule 22. I don't know. But that might be why there's been some extra stuff going on with this quality of this feed. Not just the visuals, but the internet connection. Also, Nick Starro, sending love your way. Glad to see that you are out and about today, if you consider being out and about on the YouTube streets a thing. Guys, Nick Starro was a close friend of Jeff Legal Vices, who passed away. So, you know, show some support and respect here for Nick. It's not easy to lose somebody, especially... I think, Nick, one of the reasons a lot of us know you is because of Jeff, because of Legal Vices. So show some love in the chat there. Really, I don't have enough words, but I don't think there's anybody out there that has a bad word about Jeff, and it's just such a tragic loss.
For Mr. McMullen, and I went ahead when I was addressing the rest of the remaining defendants and left Mr. McMullen.
Oh my gosh, the camera again.
Is the last opportunity.
Okay, this is the law and crime, the feed. It's not me.
Yeah, no, go
this
ahead.
time.
Go ahead. Okay, this will be the final opportunity today to enter a negotiated guilty plea, and that would be a plea that both sides have agreed to a recommendation, and if the court accepts the plea that sentences to something outside of that recommendation, Mr. McMullen would have a right to withdraw his guilty plea. After today, any plea that is tendered would be non-negotiated, meaning that if he decided to enter a guilty plea, any sentence...
What? Oh my god, you did a Pro Hog Vice? Oh my god, Jim, I'm so excited! Sorry, I'm pausing the chat because this is the stream because this is way more important. So Jim R, our happily angry lawyer, says since the cat is out the bag with the Fit Lawyer ATL, yes! Jim is going to also be representing Sledge. Oh my goodness. Oh my god. Balloons in the chat for Jim R. This is the positive, happy news we need. This is so amazing. Oh my god, I'm so excited. Okay, hold on. Because you guys hear me call Jim Happily Angry Lawyer sometimes because that's his Twitter or X username. This is amazing, amazing, amazing. So make sure you also follow him on X. We've got to get you a YouTube channel going. That would be great. But hopefully you'll also be guesting. I mean, you can come up here. I'm sloppy with guests, you guys. It's not my forte yet, but I'll work on it. So you obviously have an open door, red carpet to come up on this and talk about anything you want. But I also imagine you might make an appearance on the Fit Lawyers channel. Okay, so make sure there is Fit Lawyers YouTube in the chat as well. This is so awesome. This is so, so awesome. All the balloons, you guys. I love it. Like 99 red balloons in this chat. This is awesome. And guys, in all seriousness, aside from this being an awesome initiative that we're celebrating, just great commentary that Jim does over on X. If you want to see some shade and some criticism of Fulton County, the way that their motions are filed, their responses are filed, cases that prosecutors like Love used to work on previously, definitely make sure you're following him over there. Gonna share his X again because the chat's moving fast. And when the stream's over, I'll do like the redo of the description. So big celebration in the chat. Love you guys. This is great, great news.
That was statutorily authorized would be a possible sentence, and there wouldn't be any right to withdraw the plea simply because of dissatisfaction with the sentence. I just wanted to make sure, and I know Mr. Dark, you've told that to Mr. McMillan already, but wanted to make sure that's on the record. All right, and I'll ask Mr. Abbate to please let me know what the state's offer was.
Yes, Your Honor, on the 8th of December this year, the state sent an email to counsel for the defendant where the state agreed, or the state's offer was the defendant plead to count 1, conspiracy to commit RICO, and then count 2, but the lesser included offense of murder, voluntary manslaughter, with a sentence of 20 years to serve, all of that time being parolable or parole eligible. It's my understanding that at this time, the defendant is not accepting that plea offer. So he'd be facing a mandatory minimum if convicted after trial of life and a maximum of life without the possibility of parole plus 20 years, Your Honor.
All right, and do you understand that, Mr. McMillan? All right, and as I mentioned before, the fact that there was an acquittal of certain of your co-defendants does not mean that there would be an acquittal in a trial before a different jury with, you know, different prosecutors, different defendants, different defense attorneys. So it's a chance that you're taking, and you obviously have the right to proceed to trial. You also have the right to enter a non-negotiated guilty plea, although you can only enter a non-negotiated guilty plea to the charges that are in the indictment. I, as the judge, don't have any authority to reduce charges. So what I mean by that is, unless the state agreed to permit you to plead to voluntary manslaughter instead of murder, the only pleas I could accept would be to the murder and the conspiracy to violate RICO. So it's the prosecution's sort of venue, if you will, ability, and only theirs to lessen the charges. Okay, you understand that also? All right. Okay, Mr. Dark, is there anything you want to put on the record right now?
No, Your Honor.
Okay, and we discussed some timing already in your absence when I had the rest of the attorneys here. And what we all have settled on is the state gave an expected duration of trial of about 3 months. They think that's probably on the outside, but that's what we will anticipate at this point. We are going to have a status conference in this case on January 17th at 10 a.m. And we're going to discuss jury questionnaires and the voir dire process and things like that. And can you let me know, Mr. Dark, I know that some of you started the trial that already occurred, started voir dire, and some of you didn't, and I don't know what Mr. McMillan did. Was he a part of the past trial when it started?
Your Honor, Mr. McMillan tells me that he's in custody for the past few years with no counsel, so I don't believe that he would participate.
Okay, all right. And when did you become involved in the case, Mr. Dark?
I just was appointed, I cannot remember right offhand, but I know it was within the last 60 days, I think, Your Honor, 60 days or more.
Your entry was August.
August, yeah.
That's a lot more than 60 days. That's more like 5 months.
It's August in the other case, and then in this case, it was in July 19th.
Okay.
Yeah, 'cause
5
he has
months.
some other case or something.
All
But
right.
Your Honor, as I was saying at the last court appearance, I just got the discovery on this case on, I think, the 11th. And I don't know whatever these other matters are.
And as I said to you at the last conference, you should have been able to get all of the discovery from the, oh, you said there was no prior attorney? Okay, well, it was your responsibility when you were appointed to the case in July to reach out to the state and say, hi, I'm in the case now, I need the discovery. So I'm not going to delay the case past the trial that we're going to have of all of the remaining co-defendants. So you're just going to have to spend your holidays getting up to speed.
And to be clear, I'm not asking for a delay, I'm just putting on the record the conditions under which I'm working, and I want to be effective for my client. I don't think that he should just be forced into trial just because, for whatever reason, an attorney was finally found for him after 2 years.
Okay, well, there was no trial for him within the last 2 years. If you were appointed in July, you've already had 5 months, and you'll have at least 2 more months to get ready. 7 months to get ready for a 2-count case is plenty of time. So use your time wisely. Mr. Abbate, did you already provide Mr. Dark with the discovery? I know we discussed that on December 3rd.
Yes, Your Honor, I believe it's everything, but I'm not, I want to make sure I'm 100%.
Okay.
Yes.
All right. So the other dates. Lost my place now. Lost my place. Okay. So we are planning to at least start from the jury questionnaires that were used in this prior version of this trial, which should be filed. And any additions or deletions that you would like have to the court and opposing counsel by close of business on January 16th. And any and all motions in limine are due by close of business on January 15th. The state is going to take a critical look at the discovery and potentially narrow what is going to be used at the trial. So you should have everything now, but everything may become a smaller subset of what you have now. And so they will get that to all of the defense attorneys by February 3rd so that you know what you don't have to worry about in terms of discovery. And we are looking at February 24th to begin the trial. And sometime between January 17th and February 24th, we may before that date get the jurors into, we're envisioning them coming in to answer jury questionnaires on tablets. And so that we've got an electronic version of their answers and they're here. I mean, they may be here, they may be up in jury in the, I don't know if they'll be in the courtroom or not, but somewhere in the courthouse to answer the questionnaires, then get those to everybody and then have them back to do actual jury questioning and jury selection. So we'll talk about the ins and outs of all of that on our January 17th conference. All right. So do you have any questions for me, either of y'all, with regard to how the case is going to progress? All right. Okay. Then how about you, Mr. McMullen, do you have any questions?
Nope.
For the court? All right. Are you going to want a few minutes to
Hello? This is me. This is not law and crime.
talk with your client after this, or did you have enough time beforehand?
I wanted to follow with because he had a question when we started.
All right. Okay. All right. We're gonna go ahead and finish this, and then I'll give y'all some time to talk in the back. I want to talk with you before you go back there, though, Mr. Dark, about the appropriate way to handle attorney conflicts. All right. So this hearing is out of close. Thank you.
Right. Kick the media out. All right, so we're going to switch over. We're going to watch the press conference. Sorry about all the juggling today, you guys. I'm sorry. But we're going to switch over. What is this? Let me put a timestamp in here in case anyone wants to find it quickly on replay. Press conference here with Max Shart and Kayla Bumpus. Oh, geez.
That was something that I considered fighting. And obviously in consultation with my client, we had those discussions. But I think for the time being, it's my belief that that is what's best. Sometimes a change of scenery is important, and we're hopeful that a change of scenery and the continued support of so many people will lead to a happy ending to this story.
Do you know what state he plans to live in?
I'm not going to share that information.
Did the Alfred play a factor into accepting the plea in the negotiations? If that wasn't on the table, would you have been amenable to another plea where he still would have been free, but not?
Well, the no contest to the gang act charges was important to us. We just sat through a trial for the last couple years where we've been bemoaning the fact that people have pled guilty to gang act charges when there was no indication that whatever was done was in furtherance of any gang. So I didn't want to turn around and do the same thing. So it was important that was accepted as a no contest plea. Certainly in a situation like this, and I thought ADA Sperry said it well in court. Time was of the essence. There was really no reason for Shannon to continue to sit at 901 Rice Street to wait for the lawyers to figure it out. So we were appreciative of the state for agreeing to that resolution and that no contest plea.
We had to talk between courtrooms, obviously, to get there. Yes.
Right.
Ms. Bumpus, can you talk about the conclusion, well, not really the conclusion, but what the judge decided or not decided for your part?
Well, as you know, Judge McBurney made a decision to defer in making a decision based off of a potential probation warrant. I don't think the state knew about it or the judge knew about it, and I definitely did not know about it. So it was something that was a surprise to all of us and something that is still being confirmed.
Oh, so you didn't know going in there was a warrant, because you would have been obviously prepared for that.
Judge McBurney said from the bench that he was told from probation about the warrant. The state did not know about the warrant. Well, it's my understanding they did not, and the judge did not know about the warrant either.
So what is that like? What do you think next? Just got to sort that out.
Quickly go back to Mr. Jackson. How long has he been in jail now? Is it since the beginning of 2022?
Since March 17th of 2022, he's been in jail
And
continuously.
what's the total, I guess the amount of probation is?
So from the case that we just tried, we did not challenge the possession of a firearm from March 17th. So the jury found guilt on that one count. He was sentenced to 10 years to serve 3, commuted to the time he served. So he had 7 years of probation going into today already. The sentence is 15 to serve 3, commuted to time served, balance probated concurrent with that. So essentially today he's gone from 7 years of probation to 12 years of probation.
So given all the cases, basically it's 12 years of probation
Yes.
that he's now dealing with.
Correct.
Added 5 more to increase it. 7 more.
No, it's concurrent. 12
On the other plea they took with Judge Whitaker.
He has 7 years probation, and now this is 12 years, but it's running concurrent. Yeah.
I know there's attorney-client privilege in general. Are you able to just share? You were pretty reflective in there, talking about how he's grown up, he's learned a lot, he has 4 kids. Either one of you can talk about just kind of what his mindset is as post this chapter.
The thing about Shannon that I love about Shannon is he cares deeply about people, and I think that this whole process, and probably certainly at the age he is now, where he's more reflective, he's realized how much certain people mean to him in his life, and it's just a matter of we talk often, and I'm not going to share too much, but we talk about life, and I think he's beginning to realize what's really important in life, and I've encouraged all those people also to make sure they continue to be there for him, and he just sometimes I think we get so used to trying to survive on our own, and we forget that there's people there to support us, and sometimes we need to lean on those people, and that's what I'm hoping he will do, because I know there are many good people that are going to be there for him.
When do you expect him to obviously touch grass?
So we've already been in contact with the sheriff department. The paperwork needs to go to the clerk of court. Then the clerk of court needs to fax it to 901 Rice Street, and they need to look it over. But
shout out to Rice Street in the chat.
I'm anticipating he would be released later on today. And if he's not, then when I wake up tomorrow, that's going to be first on my agenda, is to figure out what's going on.
I'm gonna run back to the courthouse and start pacing.
I don't think so. I think everyone's just appreciative, and but I don't think anyone wants to go public to make any statements at this time.
Mr. Kokomo, how are you feel today?
Kokomo.
No, I just hope that we can keep fighting and pressing for Mr. Kendrick so we can get him out sooner than later.
And Ms. Bumpus, are you also one of Mr. Jackson's attorneys?
I'm a halfway co-counsel.
She is. She
Okay.
is.
Okay,
She's
I
being
just
modest.
wanted to make sure I wasn't, yeah.
She is co-counsel. Yes.
Does
Good.
he prefer, haven't been covering the whole thing, does he prefer Mr. Jackson or Mr. Stillwell, or what should we?
So he prefers Jackson.
Okay.
He was listed as Stillwell in the indictment.
Right.
For the trial, and I just got so used to referring to him as Mr. Stillwell because I just thought it would be easier for the jurors to keep track of one name, but he does prefer Mr. Jackson.
Is it, because I guess we've referred to him as Mr. Stillwell in the other case.
Right.
Would we say Mr. Jackson, also known as Mr.
Yeah, that would be fun.
I like that too. So, did he tell you when his first meal was going to be, when he like his first meal to be? You know, I heard rumors of the menu floating around. Do you want to know what his first meal was going to be?
I told him I got him at Five Guys. I'm simple, man. So nah.
Dennis is referring to that Twitter
He'll be
post
all right.
that X post. All right, and they cut us out there. All right. Wrapping it up real quick there. But yeah, like Kayla had posted on X like a whole list of food items that she needed to prepare. I think that's what Dennis was referencing. So we've got that. That was the press conference. We also have, I see some people are tuning in late. Again, we just heard Max say that Shannon better be coming home today. Rice Street says, I'll do my best to get him out. And Max says, first thing I'm going to do in the morning, if he's not out, he's going to run back down there. But with Deamonte Kendrick, he will be granted a bond. That was a bond hearing, not a plea. Shannon Stillwell, Shannon Jackson took a plea. For Deamonte Kendrick, his bond hearing, Judge McBurney was willing to grant it, but there is an out-of-state warrant that probation let Judge McBurney know about. They've got to look into that. And then the parties will reconvene if they can get a bond moving forward. So that's still up in the air, but I still think there's a good chance that Deamonte Kendrick will also be home for the holidays. You guys are quick. You're like pointing out the Cowboys hat in the camera view. Holy moly, you guys. And then we're going to look at, I think the last thing we've got, if I'm not missing anything, is we'll look at this state's response to Christian Eppinger's immunity motion, right? So we'll do that. Big thank you, Stacy Zivit, love the name. Gifting a membership, and then gifting another 5 here. So I know you guys like to say Stacy Zivit, so if you guys want to show Stacy Zivit some love, that would be awesome. Big thank you for gifting the memberships here. And you've got a seal. You've got a seal as your profile picture, so you definitely seem official. Stacy Zivit. Touche said maybe she tried, but she failed. She threw all kinds of shade on Ms. Love Glanville et al. So Whitaker trying not to show that she was throwing some shade. You guys peeped it anyway. It wasn't hidden, that's for sure. Totally agree. And let's see. There it is. I was looking for this. Rice Street. Holy moly. Guys, this is the only chance when you're on YouTube, right? And I don't mean only this chat, because Rice Street makes appearances over on Classy Beats and some other places. But it's the rare exception where we get to say, shout out Rice Street, and say that we appreciate Rice Street. Because we're not talking about 901 Rice Street. We're talking about the Honorable Rice Street right here in the chat. And Rice Street is freeing people today. Rice Street is giving 20 people gifted memberships. That's incredibly generous. So guys, the rare chance you can show Rice Street some love today here in the chat. So big shout out. If you don't want to type Rice Street, you can also use the rice emoji. It's all a good time. Big thank you here. And then I'm seeing Ike. Ike, you can't be saying this when Rice Street's right here. Ike says, just be doing a drive-by. Love y'all. Take care. Good to see you popping in here, Ike. Be careful out there. Be careful what you say around Rice Street here. Stacy Zibbit also says, please hit the like button. It is free 99. Cat Slimes play nasty. I do love it. I do love it. I think that started over in Flesh of the Gods chat. Brian B, thanks for becoming green. I believe you've been green before, so welcome back. Tat Clouds is like, hold on, you guys are not going to be sniping out here without me. So here we go, gifting another one. Thank you so much to Tat Clouds. Show Tat some love in the chat. Let's see. Leah's dad, and this is a perfect food for thought before we look at this state's response. Leah's dad says, Kat, in their fervor to get a conviction, did they, the state, just set up a cop to be shown perjuring themselves? He lied on that stand about the approach. Now, to be clear, as far as the immunity hearing, and I don't know if this was for time or maybe because we don't want to put him on the stand at yet another hearing, but I think Abbate made either a kind or strategic or a combination of both decision to stipulate to allow Eppinger's attorneys to use the body cam video, presumably when Officer Rogers arrives, like that body cam showing him like getting out of the car and trying to apprehend Eppinger. Abbate stipulated, we don't need to call a witness just to lay foundation to show this video or whatever. So I think in a way that could have been strategic because it would prevent yet another set of testimony from Officer Rogers or maybe the custodian witness that they brought to introduce some of the videos in the first YSL trial, right? By stipulating, you don't have a witness on the record yet again giving testimony. So I think this is a concern for the state, and it's a huge concern because they're putting a lot of weight behind this charge, presumably because it involves a shooting on a police officer, right? So great food for thought here. We're going to look at the state's written response, also look at who wrote it. Maybe it was Adam that wrote it, but I think this is a really good point here. Stacy Zibbit gifted another one. Thank you so much. STS also out here sniping. You guys are so nice today. I've got to update my banner. This has been, I feel like I forgot how to manage a stream a little bit because we haven't done it in like 2 weeks. It's not like riding a bicycle, but I've got to update this gifted banner because holy moly, we're at 125 new members. And I will add names while we are, at some point, while we have something to watch. But I do appreciate it. My bad for not doing the typical banner that we usually have up there. Let's see. Holy moly, FFS. What the heck? I was like, how did we get to 125? Oh my gosh. Okay, shout out FFS in the chat. Holy moly. Honestly, if you want, you could spell his name out, but make sure you use some asterisks. That's a big deal. We'll be a little more lax on the curse words. YouTube will get you if you spell the curse word all the way out, though. You got to censor it. That's why we say FFS. Holy moly, FFS is winning this war. In all seriousness, I appreciate all you guys just for even tuning in and watching, hitting the like button. You don't have to gift or super chat, but when you do, it's super nice, especially when it's a gift to somebody else, because that means they get to have the green name. They get to use those channel emojis. Those channel emojis, YouTube will not let me add channel emojis for like everybody to use. It's just the way the feature is set up. So you do have to be a member to use those channel emojis. So when you get a gifted membership, you do get certain perks. So make sure you're saying thank you when you get one, but holy moly, FFS. Holy moly. Oh, what are we doing here? This is super generous. It's like Santa Claus here, FFS. We got to put a Santa Claus hat on your profile picture. And it's like, I think it's still giving... I just toggled over and it's like it's still... I don't know if it's getting caught up or if it's still trying to find people to gift, which is just crazy to look at. And Tat Clouds, that's right. Put the umbrellas up. It is sliming in here. So holy moly, we've got a gifting war right in time for the holidays. In between, we've got Stacy Zibbit sniping some more, gifting another one with a snipe, and then dropping 5. So big shout out to Stacy Zibbit. Again, I should see a rolling wave of thank yous in the chat and channel emojis, so make sure you're taking advantage of those. STS is also in the mix, sniping 1, and then holy moly, STS gifting 50! Is this like a banner thing? Like, oh, there's a banner. We've got to get that number up. Is this psychology? So I've got to get you guys, look, we're going to get, let's see, thanks to... Got to get the names. What do they say? The names must be named? Let's see. Viewer activity. There's so much green in the chat, you guys, from the hearts to the usernames. This is so awesome. Let's see, we've got to get Sea Travel up in here in this banner. Got to get Paulette in this banner. Got to get Flesh of the Gods. Got to get Survivor Speaks. Like, holy moly, you guys. Well, that is a messy banner. Jim R., don't, like, redline my grammar in my banner today. Give me a pass. And then, hold on, Amber Dawn also says, with the commentary here, Viverito is on the phone, the gang unit in Harris County, Texas. Right. Right. Just, like, looking for a nice Texas bush to hang out in. Find out what we're doing over here. Keeping the eyes on him. And I'm still really curious to see if her testimony changes or she adds other reasonings or excuses to certain explanations. You know, I don't know. I don't know. So, because really, like, as far as the drinks, Shamel drinks, it's pretty much her versus Garlington for the second trial. So that's going to be interesting to watch. Kay Zulu using her member comment to say thanks, fam. Very nice of you. Good to see you. And then holy moly, Ray Street's gifting another 50. Oh my god. This is why I need a soundboard. You guys just dropped 150 gifted memberships between the two of you. Plus an extra 20 from Rice Street already dropping a 20 bomb. So I gotta update this banner again. Guys, I'm gonna read this document, I promise. But what are we up to, 225? So holy moly, and make sure, we'll play it at the end of the stream, but you can also go check out the new Michael Sprinkle song, Members Only. It'll release on the 19th. We're doing a mixtape drop. Nick Starro. Big Nick, but not that Big Nick, or the other Big Nick, says, I hope all Big Burrito finds is a barbed wire tumbleweed. Some bushes are thorny. They have their own built-in thorns. You don't even need barbed wire. Some got some spikes going on. So shout out to Big Nick, the Honorable Big Nick, not the other Big Nick or the other Big Nick. And also, I assume, I understand if you, want to take some time, but I assume you're going to do a Friday stream, right, Nick? Before I declare that you're going to do a Friday panel stream, if you want to just confirm it in the chat. But I'm assuming, I'm making the assumption here. You guys can make it a regular thing to get together, and it might not only be about YSL stuff. We talk about other topics over there on Nick's panel stream. Okay, yes, so it's confirmed. So here is the link. You guys are probably, and you should be, following Nick already. If you're not, make sure you get over there and look for that announcement on the Friday panel stream. But Nick goes live and does a lot of video uploads pretty much every day. So there's always something to see over on his channel. So if you're not following, Nick's a perfect channel to go to. Fill your void, because I'm not going to be here every day. I'm going to be over in Nick's chat. And also, Nick changed your Rumble handle to Big Nick over on Rumble. That's great. I love that. Oh, man. So big thank you again. Look at this, guys. Look at this. Like, just back to back here, 150. So show some love. FFS and STS have really easy names. Rice Street's pretty easy, too. But if you're too lazy to type Rice Street all the way out, which you shouldn't be, use that rice emoji. A big thank you again to everyone for all the generosity today. And then let's get to reading. We'll get to reading before I lose my voice. That sounds like a good idea. All right, so we are going to be looking at, make this bigger for you guys. And I forget the date, but the original motion for immunity was filed a very long time ago, and we're getting to it finally. The hearing, we heard Judge Whitaker say January 13th, 2025 at 10 a.m. is going to be the oral arguments, the hearing for, both sides to argue this motion. It's relating to the Eppinger shooting involving the police officer, Officer Rogers. So Eppinger's attorneys had previously filed a motion trying to make the argument that Eppinger should be immune from prosecution, and they offered a basis of self-defense. So defense of self, defense of habitation, and defense of others. Now that's an affirmative offense. It's saying, yeah, Eppinger did do the shooting, but it should be justified and he should be immune from prosecution from it. So this is the state's response that we're getting. Before we start, let's look at... All right, so there you go. You got the Honorable Fonnie T. Willis and by Adam Abbate. So it definitely seems like Adam's still alone at the state's table in a way, handling a lot for this second YSL trial. Shrink the screen. But state's response in opposition to defendant's motion for immunity from prosecution. Comes now the state of Georgia and respectfully submits this response opposing defendant Christian Eppinger's motion for immunity from prosecution, which defendant filed April 2nd, 2024. So there's the date. And states as follows. Introduction. Defiantly embodying the exact sort of extreme public violence that is the trademark of criminal street gangs, including YSL, defendant Eppinger, a YSL gang member, brazenly opened fire on Atlanta Police Department officers in the lawful discharge of their duties. Eppinger's continued attempts to escape the consequences of his violent and reprehensible gang crimes are both baseless and indefensible under any reasonable or legal standard. Eppinger's obvious motivation in his attempted murder of Officer David Rogers, and I think this is spelled wrong. So if you guys want to Google David and the last name Rogers, you got to either put some extra context there when you do the search, like officer shooting or Atlanta. But I believe his name is spelled Rodger. So if you want to look into this more, that will get you more results. But Abbate is arguing that the obvious motivation in this attempted murder was to evade a lawful arrest and avoid responsibility for his involvement in a recent gang-related armed robbery, targeting innocent members of our community, all while furthering the interests of YSL. In pursuing his groundless motion, Eppinger seeks a superior court in Doris Aegis to intensify his gang's malicious campaign of terror through improperly eluding the charges against him and calculated efforts to garner publicity. The court should grant no such indulgence to Eppinger. Even had Eppinger particularized his baseless motion, Georgia law forecloses immunity where, as here, lawful arrests are illegally resisted. I hate that this is formatted like this. Like it doesn't exactly look like a footer. Eppinger's motion is entirely lacking in both legal and factual substance. Therefore, this court should unequivocally deny Eppinger's motion. Now, I will say that the motion was pretty bare bones, right? But they did request to, be able to call witnesses, share exhibits, have this hearing that we're going to have on January 13th. So this seems like puffy language a little bit to repeat certain words over and over, but it was a short motion. I think it was like 6 pages, maybe 4 pages. Statement of facts. YSL's existence as a criminal street gang, the persistent and pernicious connection between violence and YSL, as well as YSL's broader affiliation with the Bloods, is widely recognized and can be readily verified by reliable, unquestionable sources. Oh, man. Do we need to put this back up? Each of these factors independently meets the criteria for judicial notice under OCGA 24-2201. And he also says Carlson v. Carlson, which is the guide that prosecutors, from what I've seen attorneys on X talk about, this is what prosecutors love to refer to. So it's commentary, it's legal analysis, but the analysis tends to be in favor of what prosecutors usually argue. So we've heard this referenced a few times in different motions. It leans towards prosecutors, and offhand, I don't remember the name of the counterpart that seems to be more favorable to what defense attorneys would argue, but there's something similar. Consequently, this court is well within its authority to take judicial notice of the violent nature of gangs in general, that of YSL in specific, and the fact that the defendant's actions, captured on video, unchallenged, and irrefutable, are entirely consistent with both. There was a footnote here, 2 and 3. So the first is citing Harris v. Greer. We can, however, take judicial notice of the fact that many prison gangs are organized along racial lines. We may take judicial notice that citizens of Tulare County and other Valley communities know that relationships between rival gangs often erupt in violence as gang members seek to protect their turf and retaliate against one another to even the score. And then Medina versus Hillshore Partners. We take judicial notice of 2 matters of common knowledge. One, that street gangs are generally claim a home territory and attempt to prohibit rival gang members from entering the area upon threat of severe physical injury. And 2, that gang activities spawns violence. See generally United States versus Espinoza. That's a 9th Circuit 2013 decision. The claim that the district court improperly took judicial notice of gang websites is unsupported by the record. Then also the 3rd footnote, United States v. Papas. We've heard that cited a few times, I think recently, right? Maybe a different one, because this is 2024. The court takes judicial notice that sources from basic internet searches generally describe the Latin Kings as a large national street and prison gang involved in homicide and other violence, as well as drug crimes. Berto v. Dunstan, the court takes judicial notice that the Aryan Nation has been recognized as a violent and powerful prison gang. Plunkett v. City of New York. The court knows enough from a plethora of cases on its docket involving one gang or the other or both to be generally aware that the Bloods and Crips are the Sharks and the Jets of today. One could probably take judicial notice of that fact. Placing Bloods and Crips together creates a recipe for violence. So all of these are supposed to be saying that the judge can, say, I'm going to, it's of note, the things that I'm familiar with, the things that are available, I can make notice of without needing specific evidence presented relating to this party. There's enough to say that it's pretty much common knowledge. Now, what do you think of that argument when we've heard Judge Whitaker already make comments about the acquittals for Deamonte Kendrick and Shannon Stillwell on count 1? So I think that's a bit interesting. But, I mean, this is a huge footnote, so it seems like Abbate might be aware of that and is like, just put it all in there. The armed robbery. On October 12th, 2021, the Atlanta Police Department responded to a report of armed robbery at 349 Cleveland Avenue. Darius Smith was standing near the playground in a park, conversing with friends when the Eppinger and fellow YSL co-conspirator approached him and demanded, "Give up that chain." The victim further stated that one YSL gang suspect pointed his firearm at his head, while the other pointed his weapon at his ribs and proceeded to steal his diamond earrings, diamond and gold necklace, 2 iPhones, and his car keys. The YSL gang suspects then entered the victim's white 2003 GMC Savannah. Is that how that's spelled? And fled the scene at a rate of high speed, turning westbound onto Cleveland Avenue. An investigation by the Atlanta Police Department led to the identification of Christian Eppinger and Deamonte Beebe as the 2 armed robbers, Eppinger being identified by Smith via photo lineup. Both Eppinger and Beebe were documented YSL gang members at the time. The crimes occurred in what is known as YSL gang territory. Then on February 7th, 2022, the attempted murder of Officer Rogers. Eppinger was wanted for an armed robbery that he committed with Deamonte Beebe on October 12th, 2021. Atlanta Police Department's fugitive unit observed Eppinger at 111 Clare Drive, southeast Atlanta, Georgia, at which time they began close surveillance and observed him getting into a Jeep driven by a female driver. The Jeep then stopped at 387 Cleveland Avenue and then proceeded to 221 Cleveland Avenue, both locations within known YSL stronghold territory. Eppinger then exited the Jeep and walked towards 2637 Old Hateville Road, Colonial Square Apartments. Shortly thereafter, Officer Rogers, the first marked vehicle on the scene, arrived in full uniform, exited his vehicle, and gave Eppinger loud verbal commands to get on the ground. Now this is interesting. This is interesting. So they're saying Officer Rogers, marked vehicle, arrived in full uniform. Look at how they're wording this. Gave Eppinger loud verbal commands to get on the ground. So they're at least not trying to make the argument that he announced himself, right? But they're just saying he gave loud verbal commands to get on the ground. But Eppinger, true to YSL expectations, did not comply. Continuing his gang-motivated defiance, Eppinger pushed Officer Rogers and gained space between the two, at which time Officer Rogers attempted to draw his taser. Before Officer Rogers could discharge his taser, Eppinger produced his own firearm and began shooting at Officer Rogers multiple times, striking Officer Rogers 6 times to include his right shoulder, above his knee, and 1 hit to the back of the head. Eppinger then attempted to fire at Detective William Johnson, who had arrived as backup as he fled northbound on foot through the apartment complex. After Eppinger fled, law enforcement issued a be on the lookout or BOLO alert for him. Members of the fugitive unit located Eppinger running behind Building 34, heading directly towards apartment 35D with a gun in hand. Eppinger then forcefully kicked in the apartment door and entered without authorization. After a recalcitrant standoff with the police, the one that Hilton wanted to show the jury in the first YSL trial on the basis that it would show and counter the narrative by the defense that police target and treat members of the Cleveland Avenue community poorly, Hilton wanted to introduce this apprehension video to show, no, they did a nice approach, a nice apprehension here. So, he's transported to public safety headquarters. During his interview, Eppinger was Mirandized and admitted to shooting the officer. After his interview and once he was transported to Fulton County Jail, Eppinger made a recorded telephone call where, again consistent with the established gang and YSL behaviors, Eppinger bragged about the shooting. Coveting attention for his crime and gang, Eppinger implored the caller to check his YouTube or to drop his music because his profile's going up on YouTube. Oof. Oof. And there's a footnote here that says, see generally United States v. Brown, considering whether various videos depicting Brown, Banks, and other gang members engage in braggadocio behavior concerning their pimping achievements and gang affiliations were unduly prejudicial. Does this footnote continue or just stop? And then the admissibility of defendant's rap video that appears to show him engaging in braggadocio about gang conflicts generally. So, all right. So they want that to be relevant here. Eppinger then continues throughout the call, laughing about the shooting. At the time of the attempted murder of Officer Rogers, Eppinger was on probation for a prior robbery. Eppinger has made no claim and has presented no evidence of excessive force on part of law enforcement. Now, this is true. This is true. At least according to the motion that I read. You know, it was pretty bare bones. Wasn't really alleging excessive force. It was defense of self and others. So to me, the key argument is going to be, would a reasonable person know that this was a police officer in this situation, right? And additionally, when we get to trial, if they're going to put forth this defense, justifiable use of force, it would become reasonable belief that Eppinger had at the time. So, 2 different questions, different standards there for the purpose of this motion versus at trial. But this is true. There wasn't really, in that motion, there was no Rogers was using excessive force. It was pretty bare bones. But that could change at the hearing on January 13th. Argument and citation of authority. In Eppinger's unparticularized, vague, and error-laden motion, this is true, you guys. Like, they put the wrong defendant name in the first sentence. They didn't swap out whoever the template motion was about, but it didn't say Christian Eppinger. It said like some A name. It was a different name. So there were errors, just like there's errors in this thing we're reading right here, Abbate. You know, I've pointed out a few. But Eppinger wrongfully asserts that he is entitled to immunity from prosecution. However, established Georgia appellate precedent unequivocally holds that resisting a lawful arrest does not constitute a legally justifiable use of force. And this is going to be the issue that's being contested. You know, was it lawful? And in that heat of the moment, was Eppinger aware of who Officer Rogers was? OCGA 16-3-21B2 provides in relevant part that a person is not justified in using force if he is attempting to commit, committing, or fleeing after the commission or attempted commission of a felony. This court has thus held that when officers are making a lawful arrest based on probable cause, they have the right to use that force reasonably necessary to make the arrest, and that under such circumstances, the arrestee has no right to resist the use of such reasonable force. This is a footnote here citing Bynes versus State. Now, what I would want to question here is if the other officer that showed up, or if you're still in fear of your safety because of not just the way that Officer Rogers showed up, but then what this other officer might do when they might rightfully worry that somebody was shooting at somebody else, right? Things can go both ways in quick moments like this. If Eppinger goes into a house and then like lays down, complies, I think the defense attorneys could make a good argument that he wasn't trying to flee and avoid apprehension. He was trying to get to a place where it was more likely that apprehension wouldn't result in someone shooting and killing him, right? I think there's a strong argument here that the defense can counter this argument here. First and foremost, Eppinger's motion is devoid of any substantive evidence or legal reasoning to support his claim that his attempted murder of Officer Rogers, committed during the execution of lawful arrest warrants for armed robbery and associated violent offenses, crimes Eppinger, and this is italicized, crimes Eppinger perpetrated while on active probation, entitles him to immunity or protection from prosecution. Now, this, I think, would go to, there might be a better reason to suggest that Eppinger more reasonably could have been aware of who was pulling up on him. This is an argument coming from the prosecution, of course, and that this entitles him to immunity or protection from prosecution. Secondly, binding Georgia precedent is unequivocal and necessitates the denial of Eppinger's or Sott's motion for immunity from prosecution. The following non-exhaustive compilation of authoritative rulings is both illustrative and persuasive, establishing that Eppinger's motion is legally untenable. A fleeing defendant who uses force in resisting his own arrest for a felony is not entitled to an instruction on the justified use of force in self-defense. There's a footnote citing, that's just Long v. State. The officers were making a lawful arrest based on probable cause. They had the right to use force reasonably necessary to make the arrest, and defendant had no right to resist the use of such reasonable force. That's Mayfield v. State. And again, I'm not really sure that part of Eppinger's defense is necessarily, an argument about the use of force. It's, I don't know who you are, you're jumping out at me. You didn't say who you were. I'm on the ground, I get up and I see you reaching at your belt level for something. Sure, it might have been a taser, but I don't know. I could still reasonably be in fear that you're about to shoot me dead, right? So I think the defense attorney isn't really going down this lane of Eppinger turned around and shot you because you made physical contact with him. I don't really think that that's the angle the defense is making, but defendant was not entitled to immunity under OCGA 16-3-24-2, and that the deputies did not enter or attempt to enter the home for the purpose of unlawfully arresting him, and that the deputies did not unlawfully and forcibly enter or attempt to unlawfully and forcibly enter the home. In light of the foregoing precedent, Eppinger's attempt to justify his actions through the invocation of immunity or self-defense is both legally unsupportable and contrary to established law, thereby warranting the denial of Eppinger's motion on its face, sua sponte, and without a hearing. So we know that this was lost. This is not the case. We have a hearing. Conclusion, the sine qua non, is that how we say that? Of YSL and gangs like it are extreme violence in public locations, often in response to a perceived slight and or authority figures. Examples are legion. Eppinger's armed, hyper-violent attack on the officers in this case presents yet another chapter in that tragic and destructive history. And again, this is all coming on the heels of almost a full acquittal, minus the one gun charge in the first YSL RICO trial. Eppinger has provided, from a jury decision, Eppinger has provided this court with no legal authority to substantiate his indefensible assertions. Additionally, Eppinger has failed to present even the slightest indication of facts that would satisfy his burdens under the established and controlling statutory and case law governing his claims. Accordingly, this honorable court should deny defendant Eppinger's motion for immunity from prosecution. Respectfully submitted on the 16th day of December 2024. You got Fonnie Willis, you've got Adam Abbate. So that was yesterday that this was submitted. And today, Whitaker scheduled a hearing. So we've got that. And this isn't a light topic. This isn't a light topic, you guys. You know, shooting at somebody. This is a moment in the trial where people were commenting on Officer Rogers' head and then found out that one of the wounds was actually to the head. He had to be like operated on because it like penetrated his skull in some way. So people were like, oh, like we kind of see it a little bit there. But on the flip side, whether Eppinger can make a claim that this was justified, and remember, some of this justification argument could still come into play at trial, even if on the 13th, the judge says, all right, I'm denying the motion for immunity from prosecution on this one. We could still see a justification argument at trial, right? Where the jury now would decide something. But you have co-defendants here. And we've got jury selection. And if you guys heard anything about Juror 409, Juror 409's husband is law enforcement, was law enforcement. I think she said he was retired. You know, Miles Farley took a plea earlier today. You know, maybe this is a factor. You might not get the same jury that you had on trial 1. And I'm sure the state's going to be trying to pick a starkly different jury than what they had on trial 1. They're going to look for a lot of 409s, where the imagery of someone shooting at a police officer, there are people out there that can't fathom that a police officer would do anything wrong in the course of their, you know, daily operations. They can't imagine an officer not announcing himself as they're supposed to. And if they didn't announce themselves, well, too bad, so sad. Still not justified for you to not realize somebody might be an officer. And again, this is the defense theory, right? They're going with he didn't identify himself. Whether that's factually true for Eppinger or not, that's still the theory that the defense seems to be putting forth as a basis for immunity from prosecution, and I'm sure possible justification if it goes to trial. And this is not a light thing for Judge Whitaker to consider, but it's very interesting. And it's very interesting because it involves a police officer. There was outrage when I think it was 60,000 or something. All this talk about bonds denied, bonds denied, bonds denied, bonds denied for these YSL co-defendants. But Eppinger was granted bond on this. So there was a lot of outrage about that because the public's like, okay, how do you shoot at an officer and you get bond granted? But there's other people, maybe relatives of mine, that have been sitting without even being charged. They're not indicted yet, sitting in Rice Street for like 200 days. Right? So there's been a lot of outrage on all different levels, somehow relating and overlapping this charge against Eppinger. Right? There's a lot to unpack. And again, I don't really know, probably won't see anything on this until we get to the hearing, because this was the state's response, and now we've just got to wait till the hearing. But a lot there, you guys. And my voice is officially gone. I had a lot of work meetings yesterday, so I woke up today with a throat was holding in there. This motion, even though it was only 8 pages, got me there. I see we've got an update here from STS from Simon. Sysadmin Simon sees the vet in 5 hours, losing the cone of shame full time. Just in time for the holidays. It's amazing. Just amazing. What a gift. Shout out to Sysadmin Simon. Always love to hear that. And I know it must suck for the pet, but I think cones of shame on pets are just, sorry, I think they're very funny to look at. So All right, so we've got a plea hearing scheduled tomorrow. Nancy New One Two says, hold on one second, we can pull that up. Before I close this, let me drop the link one more time. State response. I think I still have the thing open. Hold on. Unless you have the time offhand here, Nancy New. Let's look and see. Let me get signed in. And holy moly, I have a ton of, I was like looking for a quick update on X to see if anyone else has like posted or confirmed real quick. Tons of notifications from X from people showing love to Jim R, Happily Angry Lawyer, and the Fit Lawyer ATL, taking up that representation of Munk Tunk. So very awesome to see all of those notifications. Let's see. All right, no updates relating to this, but let me get signed into this portal. Weird. So I wonder if this is just on the calendar just because. I don't think we're going to, I don't know. Not sure. And it is possible they want two things in motion, you know, just in case. So I can't say that this isn't the case, but I wonder if this will get booted forward while they're trying to consider bond because, you know, if someone's basis for wanting to take a plea is because they don't want to be in custody, if a bond could be on the table for you, that might change what you want to do as far as a plea. So I'm not sure, but we'll pay attention to this. And of course, if any small updates between today and tomorrow, I'll post it on X and as a community post. So, but good catch here. Can confirm that it actually means someone's taking a plea. I think this is just a calendar block. Big thank you also Survivor Speaks out here gifting another 5. My banner is like not even here. Let's get that banner back up. Show Survivor Speaks some love. And again, you guys, a lot of YSL content with Survivor Speaks as well, but in addition, covering other cases. So if you guys like trial watches, if you like trial commentary, Survivor Speaks. Make sure you click that link that I just shared in the chat and hit that subscribe button for Survivor Speaks. Come hang out with me in the chat over there. And okay, I don't see anything scheduled live, so you might want to hit the bell as well. Let's see. Leah's dad says Bloods and Crips is a disaster, but YSL is a hybrid gang. Look, I don't know, and I think it's a very different argument, like, to make the argument that because other judges have found that it's established and doesn't need to be established by evidence in court. You might need to establish that somebody's affiliated with or associated with or a member of a particular gang. But to argue that, I don't know. And it's rough because of these plea deals, right? These pleas that people have taken where they've acknowledged that YSL is a gang, right? But on the flip side, when you have a jury, they say no gang, right? So you have Adam Abbate trying to make this plain across the board argument that everybody knows that YSL is a gang. There's so many reasons that show that YSL is a gang. No different than people knowing that the Bloods are a gang or the Aryans are a prison gang or whatever the argument is. a jury didn't agree with that in the one opportunity a jury's had to come to that decision as it relates to this YSL indictment and the claims that YSL is a gang. The only acknowledgement in any type of disposition of a case is through a plea, and the acknowledgments in a plea. And what do we have going on with Mungtung's plea, right? There's some problems in these pleas. So unfortunately, it's still a conviction. Certain things were still acknowledged, but it's just kind of a messy system. So, but I don't know what the judge is going to do with this. I expect we'll get some snark, but there's enough there. And Whitaker, she even highlighted today during the status hearing for the remaining co-defendants, like a different jury might find something different. Acquittals are rare. So just because we have an acquittal, the other jury didn't, think RICO was there. They were looking for the enterprise. That might not be the case with a different jury. So it's food for thought. It's a messy food for thought. It's like, you overfilled the bowl, it's spilling over. It's a hot mess. Mars Get says, Kat seen that the state moving along on the Thomas murder with Mullins. They're going to subpoena Woody and Zachary again to testify. He needs to disappear. Now, I am also very interested in seeing this go down. Like, this is crazy to think about, right? If they want to, for the Donovan Thomas, to me, one of the major pieces of evidence that is helpful to the state, according to the state, is Woody's jail interviews. Same thing with Quindarius Zachary. But at the same time, getting them on the stand might be an even bigger disaster than it was the first time around. So, I don't know. I think it's a double-edged sword, catch-22 type scenario where they've got to do it, but also it could hurt them to do it, but they've really got no choice. And it really is only Demise McMullen up there on the chopping block for the Donovan Thomas murder. What I also think is crazy, I forget the specific plea terms that they offered McMullen, but for Deamonte and Garlington, they were willing to offer him a plea of manslaughter for Chamel drinks. Now, based on their theory of what they allege, for them to allege that this was some with malice aforethought, and we care so much about the victims, we have the family here for impact statements, and then you're willing to offer manslaughter, seems kind of like a slap in the face. I'm not the family, though. I'm not in that position to say how they feel. But me personally, if I was in their shoes, I'd be like, how did we switch from this to that? Right? I'd feel pretty slighted. But again, different lead prosecutor on this case. So that could be the explanation there. Just crazy to think about. And it's not every day you get to see all of this big picture YSL indictment and the way that it's playing out and moving through the court system. It's not every day that you get to look into it this way, with half of it being streamed, a good portion of it being streamed, access to all these motions, tons of coverage, interesting witness testimony, right? It is an interesting thing to see. Thank you for the 20 here, Mars Get. And let's see. The World's End, this is true. We also have Paige here for at least all, if they call Woody back, all of it will be with Judge Whitaker on the bench. The World's End says, I think Paige will want strict parameters in the questioning of Woody while sticking to a 90-day trial. And again, that's 3 months, not 90 Monday through Friday court days, right? Big difference there. But yeah, with Woody being on the stand for as long as he was, especially to play all of these calls, which Whitaker allowed. Whitaker allowed the extended play of these calls. Maybe she won't do that this time around, or maybe Abbate won't approach it that way. Oh, but yeah, I mean, that could put you 2 weeks in just with Woody. So I don't know. Yeah, Chloe Albert's Revenge, who knows? So no 8-hour video plays. We can only hope. And again, at the same time, for what it's worth, it's possible that not playing these long, drawn out, no interruption, no contextualization, no pausing to highlight what's important, extended videos, that strategy could be helpful to the state, right? That's something that could have helped them in trial one. It's something that could be a helpful strategy regardless of who's actually on trial. But just the idea that it's not easy to sit there and listen to something for maybe 4 hours, then you take a break for lunch, you listen for another 4 hours. If you're not stopping and pausing and asking questions to highlight to me what I'm supposed to be listening for, I'm going to miss it. And we had a chat here. What are they saying? Did they just say this? We had a chat here to keep us engaged and work together to notice and hear certain things. But a juror, when you're sitting there in kind of like your own little seat, you don't really have that. So strategically, this could end up being a positive for the prosecution in a bubble, like without any other factors at play. Yes, big shout out for Always Forever for Life. Thank you again. The kind words here. Everybody pray strength for Legal Vice's family and their loss. Definitely lost a good one. Huge fan of Legal Vices, guys. I mean, half the time when I said I can't wait to go back into the bushes. Like, Legal Vices, I've spent days, weeks, months, not to get Friends theme song, but just hanging out in his chat with him. So it's just a huge loss in the YouTube space. And again, his friends and family. Again, Chloe Albert's Revenge, another person knew before ever seeing Chloe over here hanging out with us. And I always appreciate you popping in here. But somebody that I consider like an online friend. I used to laugh at your commentary over there all the time. There's just so many people I wouldn't know without Jeff from Legal Vices. So all the love here. I'm sure somebody's cooking up. If you guys like want to catch a good tribute, another attorney and streamer, Aussie Overlord, did like a 2-hour sort of like tribute live stream yesterday. Chat replay, everybody was in there hanging out. So if you want to remember Legal Vices, you want to check that out. It was really cathartic. Let me just make sure he still has it up. I'll drop a link. Okay, so here is a link to that. The Aussie stream in tribute to Legal Vices over there. There was a great moment where Aussie was muted. He was on his cell phone. He was like outside doing the stream, so he wasn't at his desk. It's like, I don't think you can really see the chat when you're on StreamYard or whatever on your phone. It's not as easy to see. You have to like choose what you want to look at any given time. So there was a point where he was muted for like 10 minutes straight. And the whole chat is just like, this is Legal Vices giving you a boomer moment from above. Just like really cathartic. Good laughter, much needed laughter over there. Okay, wait, and the live for tonight from Doug Weinstein. So he's posted to his TikTok. I don't know. My bad, Cathy. Unless it was like earlier than... Oh, okay, I see it. It's further back. Okay, so there's a registration link here. I guess let me get the TikTok link. Oh, it says yesterday. It says it was yesterday. But does it stay up all the time? Does it stay up by default? Well, I don't know how to tell if either of these are like lives or just clips. But here's Doug's TikTok. in any case, you guys can check that out. But I think that was yesterday that he was actually live. With that being said, you guys, I think we are all caught up. I'm sure there's like so many little details of, you know, happenings, right? There's a lot going on. Everybody's immersing themselves in other cases. Please don't take it personal if you send me something about a case and I don't really have like a response, or, you know, I try to at least look in and get an idea of everything. And I'm at a point where there's so many cases that everyone's like, look at this one, that it's overflowing. Like I don't have the time to get a cursory view at the number of different things that are interesting out there. So please don't be personally offended if I don't talk about or have commentary on a specific case or issue. That usually means I just don't know enough to have a comment, right? I haven't had time to look at it, and I don't like to just say something without having any context at all. But with that being said, don't ever feel like, hey, I don't want to bother Kat, because at the very least, I can typically reshare something and somebody else might be able to be interested in it. If I don't have time to look into it myself, always happy to reshare. Little Dirk case might have gotten pretty interesting, right? So with the Dirk case, and I'm not a lawyer, but Mel has been going to the hearings. And I highly recommend following her on X, because sometimes when she's in the courtroom, like, she's not going to be able to just also be on a YouTube stream. So if you use X, you know, sometimes those text updates, especially with a federal case where there's no live stream feed, you know, people that are in person in the courtroom, you can get great updates from them. Mel's an all-around great person, great creator, so I say you should follow her anyway. But if you're interested in Little Dirk, she is there. She's going in person. So, oh yeah, we need to cover the Williams trial, the guy from earlier. Oh my gosh. I mean, McBurney does have his streams, you guys, so who knows? We can tune in on his calendar days. YNW Melly, I think I might cover, because YNW Melly is something that I watch with Legal Vices, and that's where, if you heard me say, I was going to watch round 2 over there on his channel. I think that's an extremely interesting case. YNW Melly, he was apprehended in Broward County, but he's, you know, like, the night after the shooting, he was out in Melbourne, so some of that's really close here. It's not that far away. If I ever need to pull up, I can get to a courtroom if needed. And I might cover it because some of it's kind of the opposite, right? In the YSL trial, we see them using lyrics and social media posts against the defendants here at the trial, and kind of, I guess it's not that much of an overlap, because there are instances where in the YSL trial, we're putting blinders on to other songs by people that were not claiming to be part of YSL, or we're not indicting that might be part of YSL, like Woody and Threat, maybe with the homicide video. You know, all these things that we're blocking out and we're tunnel visioning on to push our case and prosecute the select list of people we chose to indict. Right? With the YNW Melly case, I think there's all the shenanigans that warranted a retrial, some issues with things that shouldn't have been searched. We also have, it seems like detectives didn't want to look at potential third-party culprits. And I'm going to look into that. I want to give a big shout out to Boom Beeks. I don't know if he's in the chat today hanging out. But there's someone that was out there bragging very heavily right after this shooting happened. And posting song lyrics, beef, disses, posting what looks like he's holding YNW Melly's chain, posting targets and body chalk outlines. And this is all within the 24 hours of the shooting. I don't know. Because it seems like if YNW Melly was using that stuff, they would hold it against him. But they didn't look at it. And his attorney has been fighting to be able to introduce evidence of a third-party culprit since the first trial. So I think I have to do a refresher, so there's a good chance that I might do some rewinds on trial 1, because it's been like, I'm like a year removed from it at this point. But it's just, there's a lot of interesting things there. So, and, oh, okay, so Touche, I mean, shout out to I'm Not a Lawyer anyway, but is this about, did she do a YNW Melly update also? Or do you mean Dirk? Again, my general rule here, right? Rule of thumb, just follow Mel. Just follow her. Let's get her YouTube up here and you guys can go check it out. Because it's very possible she did one about both cases. Yeah, okay, so right here, there's one with YNW Melly. So this is awesome. So there you go. And again, same as usual, make sure you hit the subscribe button. That's linking to her specific video over here, but also just hit that sub so you can check out other cases she's covering. She's really talented and skilled with the way she does her recaps, right? So if you don't have the time to follow a million trials live, you can watch whatever trial you prefer live stream, but catch her recap. She does a really good job wrapping up all the important details. And I really think she's very intelligent, very analytical and balanced, but she's also entertaining, right? Kind of like that good mix of all the bits and pieces that you look for to enjoy watching something. So all the love here for Mel and her whole community. Let's see. Okay, Mickey Truth. I think that's a new one to me. So let me pull up a link and I'll drop it. Oh, no, I know Mickey Truth. Holy moly. Okay. My bad. As soon as I see the profile. My bad. This is me not knowing names. So here you go. Mickey Truth is in the chat if you want to hit that sub button. And at a quick glance, I see also Lil Durk coverage over there as well. So YNW Melly and Lil Durk. Probably a good place to hit that subscribe button, you guys. And then who is, I don't know why I always forget Bryson's name. Over on X. This is like, you guys have heard me do this like a million times. All right. Gonna get one more link for you guys. Probably the best on X for YNW Melly coverage. Bryson Paul. Okay. I don't know why, guys. I'm so sorry. Like, and I followed him for like the longest time. I see his posts often because he's always doing quick coverage. He's always posting all the exhibits for the YNW Melly trial. And his name always messes with me and I feel so bad. But definitely, if you want the quick documents, I mean, you can see from a quick scroll here, like just sharing all of them. You don't even need to open the documents. He takes the time to take the pictures so you can read them right on X without having to pull up Google Drive. So really awesome resource here and coverage for the YNW Melly trial. So definitely check that out. I'm so sorry. If he ever tunes in and sees me like not remember his name, I'm so sorry. Oh my goodness. But there's that, you guys. Thank you everyone for coming to hang out today. It's always a pleasure. And let me add, I'm going to add this Michael Sprinkle song here. And we can play it as the outro of this stream. And while this is playing, I'm going to find someone that's live and set up a redirect. I'll type in the chat who it is. But see you somewhere else. Shout out in the chat if you want to let us know where you're going. But other than that, you guys, here is... It's still processing. As soon as it's done, we're going to play it. It's a Michael Sprinkle song. I hope you enjoy the song, but really, it's also memories from the chat with you guys coming up with hilarious mixtape, album names, song names for Michael Sprinkle. All right, we've got it. So thanks for hanging out. See you guys soon.
Sprinkling in the cut, calling back up tonight. Fixing what they broke, truth back in the light. Baby shark grin, but the bite's still tight. No flex, no drip, just keeping it right. Empty words they fade, but truth will remain. Lifting up the veil to break the state's game. Case crashing hard, but he won't do wrong. Echoing the truth in sprinkle song. Replay all the jail calls, what do they say? Hold tight to the wire that's guiding the way. No need for a laptop, just honest and raw. Truth's back in demand, Slack, give it your all. Spencer write rumors, but the facts cut through. Whispers turn to roars when the cat is in view. Stand tall, sprinkle, don't let the lies win. It's the state's game and you can't give in. People come and go, but the real ones stay. Lil Mike and Quez, no, don't even play. Lizard walk the line, don't waver or bend. In this world of snakes, be the slime they commend. Replay all the jail calls, what do they say? Can't undo the past, but can't change today.